entire law review really appreciates your attendance. It makes events like these possible. A couple housekeeping items. First and foremost, parking. Make sure you've done that. If you need help with it, someone out in the hallway at the registration desk there should be able to help with that. For those of you obtaining CLE today, you should have received a green half sheet of paper. An activity code will be given out at the end of the event for that, and then please make sure to turn it in at the registration desk along with the survey that you've been handed. And we'd really appreciate feedback on the survey as well. So I think that was offered to everyone. If you didn't get one during the break, you can grab one in the hallway. The topic of civility really, I think we see incivility everywhere. We see it in our politics. We see it online, on social media, even in our day-to-day interactions. And unfortunately, I think it has the ability to trickle down into all sorts of areas, including the legal profession. So I thought the topic was timely, and I think civility is very important, not just for students, but for practicing attorneys. It affects our clients. It affects the work you do, the work life of an attorney. So I thought it was very important, and I hope you have a lot to take away today. We have two great panels. The first panel talking about the then, the now, and the next, where things have been, where we're at now, and what we can do for the future. And our second panel will feature Chief Justice Kennedy, Justice Welch, and Judge Knepp, who will talk about civility in the courtroom and hopefully have some great practical advice that you can take away. With that, I want to introduce Dean Rebecca Zitlow. Rebecca Zitlow attended Yale Law School. She's been with the College of Law since 1995. She has advised the Law Review from 2006 to 2011 and again in 2013. We really appreciate all that she does for the school. These events are not possible without her and her leadership. And I want to say one more thing, too. She served as interim dean for some time. She was recently appointed and named our permanent dean of the law school, the first woman to serve in that position. So we're very proud of her. And on March 18th at 5 o'clock, we'll have an event. If you walked in today, you probably walked past our Women's History Project Wall of Fame. And we have some great people, great women who have done some great things in law. And Dean Zitlow will be joining that wall on March 18th. So we hope you come out for that event. And with that, please give a warm welcome to Dean Zitlow.
Thank you so much, Ed, for that warm introduction, those kind words. I'm so excited to be able to welcome you all here today to this Law Review Symposium. As you know, this is a highlight for our year at the University of Toledo College of Law. This year, Ed, Lauren and the rest of the executive board and members of the Law Review have brought us a wonderful symposium on an extremely crucially important topic. And so I just want to thank all of you for all the work that you've been doing and that you have done and that you will continue to do, editing some of the articles that are going to come out of the symposium. So let's give the Law Review a round of applause, please. Civility and collegiality is a crucially important issue. As Ed said, it's really sort of the topic of our times. And it's something that we've been focusing on a lot at the University of Toledo College of Law. We start talking about the importance of being civil and collegial with everyone that you interact with from the very first day of orientation. We have a Toledo Way Speakers Series, which highlights these issues and highlights the fact that the Toledo law community is known for being particularly collegial, respectful, and basically treating each other well, decently. And so we're very, very proud of that, tradition in the university, in the Toledo law community, and we celebrate that here at the College of Law as well. So this is just such a fitting subject. And I'm very, very excited and looking forward to the papers. We have some of the top scholars in the country that will be speaking on these issues. And then, as Ed said, a distinguished panel of judges that we're very, very honored to be welcoming here to the College of Law. So without further ado, I'm going to, I guess, Professor Harold, you're going to be taking it away. Thank you. And this is Professor David Harold. He joined our faculty this year, but he's been a member of the Toledo law community for over 20 years. When he graduated here, he served as a prosecutor in Wood County, and we're just really, really excited to have him here on the faculty.
Thank you very much. I appreciate that. Excuse me. Yes, I'm very honored to moderate this panel today with such distinguished legal scholars. Who will be speaking on the panel this morning is David Grenardo, a tenured professor of law and associate director of the Holleran Center for Ethical Leadership and Professionalism at the University of St. Thomas School of Law, that he joined in 2022 after teaching at St. Mary's University Law School. Professor Grenardo earned the prestigious Warren E. Berger Prize for his article on mandatory civility for lawyers awarded by the American Inns of Court, and he received the national award and made his acceptance speech at the Supreme Court of the United States in 2023. Professor Laurel Rigertas joined Northern Illinois University College of Law faculty in 2006. She teaches professional responsibility, torts, advanced torts, products liability, and a mindfulness course for law students. Professor Rigertas' scholarship focuses on the legal profession, particularly in the areas of ethics, professionalism, and the unauthorized practice of law. Professor Nicholas Seger from the University of Dayton Law School is the interim director of the Academic Service Program and associate professor at the University of Dayton. In his role, he works closely with students on developing skills necessary for academic success, bar passage, and professional achievement. He also regularly teaches business organizations and remedies. Before joining the University of Dayton, he practiced in commercial litigation and discovery law and clerked for Judge James G. Carr of the United States District Court for the Northern District of Ohio, as well as the Michigan Court of Appeals. Please join me in welcoming our distinguished panel. So our panel discussion today, again, as Ed mentioned, is going to look at civility then, now, and in the future. And as an opening, I guess, issue for each of our panelists to commentate on is the idea of what does civility mean and what it doesn't mean. And of course, looking in that regard at how civility, ethics, and professionalism all coincide and work together in a symbiotic relationship while having their own unique features, as well as looking at what civility means in the classroom, in the courtroom, and in the general practice of law. So I guess as an opener, it would be interesting to get your take on when you hear the word civility. What does that word mean to you? What is most misunderstood about that word, and why? Professor Rigertas, if you'd like to kick off.
Sure. Is my mic working? Testing, testing. Good. So for me, I think it has two components. There's sort of an external behavioral component, which maybe we could think of as manners. And then for me, there's also an internal component, perhaps a moral aspect to it about how we treat others. So an internal belief in the humanity of others, and that other people are worthy of our respect, even if we don't agree with things that they are saying. We don't need to dehumanize them. So for me, it kind of has both of those components.
Thank you very much. Professor
Can you guys hear me in the back? Would you rather not? So I've been writing about this for 15 years. The way I've defined civility is in terms of lawyer personal conduct, is treating others with courtesy, dignity, and respect, as well as demonstrating honesty, cooperation, and restraint. So civility is often linked and used interchangeably with professionalism, which is supposed to indicate a higher standard of conduct than ethics. And lawyer ethics is pretty much defined by the rules of professional conduct in each state, which are based on the ABA model rules of professional conduct, which I know we'll talk about here briefly. So there's a little bit distinction there. Probably the biggest misunderstanding is that civility in the legal profession is about being nice. And when you talk to law students, and I practiced for almost a decade in LA and Houston, you can't lie to law students, and they don't fall for things and platitudes and nice things like that. Clients want lawyers who attack. And this is my Cobra Kai portion of the talk. Strike hard, strike first. And I tell my law students, attack, attack, attack. But you attack the other party's arguments, you attack their evidence, you attack the merits of what they're saying. You don't need to attack them personally, and you don't need to attack the opposing party personally either. So, but that's probably the biggest misconception out there about civility.
Yeah, I would absolutely agree. It goes well beyond simply the tone and the politeness of the way that you act. I'm not sure that my mic cut out. Okay, I'm still good. For me, what it really means is civility is acting and interacting with people in a way that really builds up the profession and, in the eyes of the public, creates that respect and reverence that we hope that we ultimately deserve. And so it's another way of protecting and furthering our profession in just the way that we treat people, each other as attorneys, the bench, the bar, our clients, and how we interact with the general public in a way that really gives us legitimacy as a profession.
Thank you very much. So when we look at the outset of civility, there are a couple of key events, I guess historically speaking, that I guess were hallmarks of seeing how the development of civility occurred, quite frankly, through the context of incivility. And one of those key moments were the events surrounding the Watergate hearings by the Senate Judiciary Committee and the Senate Watergate Committee, which really created the movement within the profession for the creation of the model rules, both in its broadest context, as well as the teaching of ethics in school. And I think it's interesting to then look at how civility worked into what occurred really as an outgrowth of the Watergate hearings. Professor Rigertas, in your work, including you've done works on civility as well as the role that Watergate played, and have spoken at a number of really well-known conferences. I thought it was fascinating that you got to speak with John Dean on a panel. And if there's a lawyer that knows about Watergate, it's John Dean. And you've spoken to the larger ethical implications that have occurred for the legal profession coming out of Watergate. What are the most relevant lessons that we get from the Watergate hearing and its, I guess, its aftermath as it relates to civility and ethics in the law profession?
I think, and for those of you who were born after 1972, John Dean was Nixon's White House counsel at that time. So I think maybe a couple of things were happening at the same time. So Watergate, there were over 20 lawyers who were wrapped up in disciplinary proceedings in the wake of Watergate for various roles that they played. And I think one of the biggest kind of shifts that was going on was lawyers at one point viewed themselves more as a public citizen. And then there was a real shift towards hired gun. And I think Watergate was maybe a tipping point in that shift, because I think the lawyers involved got to a point where they somehow believed that the ends justified any means in terms of what they were doing for their client. They also, one of the things that John Dean said during that conference that really stuck with me was that he lost track of who his client was. He thought Nixon was his client. it wasn't. It was the office of the presidency. And so I thought that was a really interesting thing also. So in terms of, being a zealous advocate and what we need to do as lawyers is a really important role, but also keeping in mind that the ends can't justify any means. And my big kind of picture takeaway from Watergate was that it was a point in time where a large number of lawyers somehow lost sight of that. When John Dean was testifying before one of the committees, he had a list in front of him, because at one point he becomes cooperative. He had a list in front of him of names of people who were involved in, helping to break into offices and to cover up. And there was a thought about trying to firebomb the Brookings Institute because there were papers in there that they didn't want to come out, like all sorts of stuff. And he had asterisks by a bunch of the names. And somebody asked him, what are those asterisks for? And he said, those are all the lawyers. And he's like, I'm just looking at this list, trying to figure out how many lawyers got themselves in this position. And I think, we also, we've gone through the 60s at that point, right? We've got a lot of, unrest going on in the nation over Vietnam. We had the Chicago 8 trial in 69, 70, so I think this also, again, sort of circus scene that we saw in a courtroom there. So there's just kind of a big shift going on in that time period that I think created the space to think about, whoa, do we have it right here, or do we need to start revisiting our rules?
Do you think in that regard that President Ford, after Watergate, with the appointment of Edward Levy as Attorney General after John Mitchell had been indicted, which is never good for an Attorney General, do you think that was a key moment in trying to right the ship from an ethics and civility point of view?
Probably. I mean, I think not only government, but the legal profession took so many hits in terms of its integrity that you need to do everything you can to try to rebuild at that point in time. We also see the ABA, soon appoint the Kutak Commission to review the rules of ethics for lawyers and think about how we need to revise those. And in particular, talking about the organizational client, because that was one of the big things that the rule revisions tried to address, is when you are representing an organization, what are your obligations?
Thank you, I really appreciate that. Professor Grenardo, from your experience, do you think the profession used to police civility more through culture than rules?
Well, the good old days weren't always good, and in the 80s and 90s there were a lot of Rambo litigation tactics, meaning it was scorched earth. It was, we're going to do everything that we can do to win. We're going to be obstreperous jerks with opposing counsel. And the response to that was in several ways by the legal profession. One was over 140 state and local bar associations created civility codes or professionalism codes or creeds. And Professor Donald Campbell was an individual who looked at all of those codes and came up with 10 common core concepts, which we're going to talk about a few of them later on. We talk about civility rules. So that was one of the responses, were these civility codes. And most were aspirational. Nearly all were aspirational. So very few, we're going to talk about those, were mandatory. Another thing that a lot of states started to do was add the civility language into attorney oaths. So when you become an attorney, you take an oath. And ABOTA, which is a great organization, the American Board of Trial Advocates, it had a huge movement towards, they called it Civility Matters, and part of that movement was adding civility language into these attorney oaths. So now there's about 24 states that have civility language in the oath. One of the few that actually makes it mandatory is South Carolina. So South Carolina mandates civility through its oath, and actually had, in I think early 2000s, had every lawyer who wanted to retain their South Carolina law license retake the oath with this civility language to put them on notice. So there's your due process, the fair notice part of it. Another thing that happened was an explosion of CLEs, and a lot of people, entertaining CLEs, a lot of people were doing those and showing a lot of egregious behavior by attorneys. So that's been the response by most, for the most part, but then 5 states have mandated civility for their lawyers. So South Carolina does it by their oath, Arizona also does it, Michigan does it by a couple rules of professional conduct, and then 2 other states, Florida, by some Christmas miracle, that's not civil, is it? Florida's another state, and they have a lot of ways that they create the mandatory civility. And a state that doesn't come out, the attorney of the office, I played football at Rice, so I've had 3 concussions when I played, and they're now coming out. But don't worry, they haven't affected me a bit. All right, this is a tough crowd. For those online, there's a lot of laughter. So New Jersey, actually, the Office of Attorney Ethics, there we go, they don't come out and say they're a mandatory civility state, but the opinions, especially by their Supreme Court in New Jersey, indicate clearly, and they have a rule of professional conduct which incorporates civility. So they are indeed, in fact, a mandatory civility state. So 5 states do that. Several federal district courts also have mandatory civility. So I've been arguing and promoting mandatory civility for years. I hope that's where we're going, and I know we're going to talk about that later as well.
Now, and you spent most of your litigatory career in Texas, and you had mentioned Rice in Houston as well. The idea of Texas-style depositions, I guess, made infamous by Joe Germail, a famous personal injury attorney in Houston, that was commonplace. Has that changed, that, I guess, extolation of treating people poorly? Has that changed somewhat now with the change in civility codes?
It depends, and it also depends on the city. So I practiced actually over 6 years in California, in Los Angeles, and then about 3 or 4 years in Texas, in Houston. And Texas, interestingly, is one of the states that added civility language to their attorney oath, but did so with the explicit understanding that the oath could not be the basis for any type of lawyer sanctions or disciplinary action. So there are some lawyers who realize that they can still get away with uncivil behavior and they won't get sanctioned for it, although there are major costs to it as well. And I know we're going to talk about strategic incivility later on as well and dive into Joe Germail as well.
Thank you. Professor Seger, even before social media, lawyers could create harm through extrajudicial conduct. What's the line between the older forms of reputational damage and what we see online now?
Yeah, so I'm just old enough to have grown up in the interesting time before the internet was really prevalent, and then having that as a big part of my childhood, and then now it being such a huge part of our daily life. And so I did think about and see that transition over time. And one of the things that I think about is that the internet and social media hasn't really changed the problem so much, but it's changed the mode through which we can express ourselves. And that includes when we're being incivil. And there are a couple of things that really accelerate and magnify the problem when we have internet and social media. One is just the speed at which we can post. We're self-publishers now. We don't have to go through some intermediary where there might be another set of eyes, or it might at least take us long enough to write a letter that we can self-reflect and pause for a moment before we post. Another thing to think about is just the audience of who we're speaking to. If we write an email, we write a letter, we speak with somebody in person, we are forced to think about who our audience is and how the audience is going to receive the potential message that we are putting out and giving them. If we talk to somebody in person, we're going to get that immediate feedback. If we go beyond the pale in speaking with that person, they're hopefully going to say, hold up a second, let's talk about that, or I think you went too far there, or at least through their body language, you'll be able to tell and get that immediate type of feedback. But when we're looking at social media, it's very different. We post, it's immediate, and it's a general audience. It's not necessarily a particular person that you're thinking about communicating with. And so that is kind of dangerous in the sense that it doesn't force you to pause and self-reflect before you post. And another thing to think about is it doesn't give us that type of it seems a little bit to contradict itself because it's immediate, but it doesn't give us the immediate feedback. Right? If you post something on, I'm old enough that Facebook was popular, I know now it's Instagram and TikTok and everything else, and I'm getting around to those, to learning them, but it's not like if you're talking with somebody, you don't get that instant feedback, right? You post, maybe you go to bed, it's 8 or 10 hours later, and now potentially half the world has seen your post, and you're getting the feedback later in a different means that doesn't help you to self-correct in the moment. And that really can be problematic when we think that those issues and what you're putting out there can be captured and shared essentially forever. And so it's not a new problem, it's simply just amplified and made a little bit more concrete in the internet space.
It's interesting, earlier in my career I did a lot of work on Harry Truman, and when he retired, they were going through his desk and they found a whole host of letters that were vitriolic but that he had never sent. In fact, the one letter that actually made it to the mailbox was when his daughter Margaret was singing at the Washington Opera and was panned by their artistic critic, Paul Hume. And it was so famous because it actually got into the public realm. Hume actually framed it and put it in his office at the Post. What kind of steps can we take as lawyers to be more civil? I mean, we don't live in a world of writing letters and putting them in our desks like Harry Truman did. But is it as simple as not clicking send?
Yeah, I think it is. It's creating for yourself a protocol, more or less, essentially thinking about procedurally, what am I going to do anytime that I'm posting on social media? I'm going to think about, is this something that I'm posting, is this substantively important? And what is the substance? Is this something that's potentially controversial? If so, I need to self-regulate and moderate myself to the extent of I need to take a look and make sure that what I'm putting out there is appropriate. So it is just pausing to some degree. But also, when you do have issues that relate to a client or potentially contentious type of posts, just have the wherewithal to go to somebody and ask if they think that this is appropriate or not. It might seem like a lot, but it can save you a lot of headache later on. And finally, just pause a second to do that cost-benefit analysis. Why am I posting here? What benefit is this going to bring for myself, for my client, for any part of my life? And then is the cost of putting something more controversial out there really worth the potential benefit that it's going to potentially bring for me? And I think more often than not, what we find is with these more damaging types of posts online, the only reason that we're posting is typically emotional, or at least that's the primary driver. And so if we do that cost-benefit analysis, we realize there isn't really that much of a benefit besides going and kind of venting a little bit. And there's better ways to do that than posting on social media. Maybe talk to a friend, go see your therapist again, or something like that.
Well, thank you. I appreciate that. Now, looking at civility looks like now, and again, I know we've done it to a certain extent with defining civility, but what does incivility look like? I mean, I know it's hard to define both civility and incivility, and we look at it through examples, but when you heard the word incivility, what does that mean to you? Yes, that will. Thank you.
Sorry. Is my mic better for those checking the mic back there? Okay. So I think of it in two buckets, the strategic or tactical incivility, where somebody is deliberately engaging in conduct that they think is going to give them an advantage. Like I remember I was at a deposition and it was deposition of my expert witness, and the other side had not asked for his documents before the deposition, which is like rookie mistake 101. So we brought no documents. And it was, we had flown to New York, and the opposing counsel and I, because that's where my expert was, and the opposing counsel just kind of lost it that we didn't have the documents. And I don't think it was a failure of emotional regulation, which is sort of the other way incivility happens. I think it was deliberate because I think his associate had messed up, had not asked for the documents. I was still a pretty young lawyer, and I think he thought if he blew up at me, I would fix his mistake for him. Tellingly, he asked to go off the record, have the court reporter stop recording what was happening before he turned red in the face and foaming at the mouth and pounding the desk, threatening me with sanctions because I was not producing documents that I had no legal obligation to produce because he had not asked for them. So sometimes we have that kind of behavior. Maybe he just lost it, but my sense was it was all deliberate. It was performative because he thought that was going to get him a strategic advantage in that moment. It did not. So that's, we can talk about that more in terms of this sort of tactical strategic incivility when people think that it's going to give them an advantage, or sometimes it's because they think that's what their client expects of them. So I think we also have to think about how we manage client expectations about what our job is and what we can and can't do. And then the other form is the emotional, like a lack of emotional regulation in the moment, because there's something going on that has just irritated us and caused us to not bring our best selves to that moment, right? So it can be because we're stressed. We might be carrying something that doesn't even have to do with this moment, right? Maybe somebody cuts you off in traffic in the morning and you're all ticked off about that, and you get into the office and you're snappy with someone because you're living in the ghost of the 15-minute past. That sort of rush of adrenaline has a protective purpose in the moment when somebody's cutting you off, but it doesn't serve any purpose 15 minutes later when you're safely in the office, but we might still be carrying that. Right, so if we are stressed, if we are overworked, if we are just, sometimes our incivility might be retaliatory because somebody is behaving that way towards us. We feel like they don't deserve civility from us and we get into this cycle of incivility. So I often try to think about it through the lens of, if civility is a value I hold, are my values conditional on how other people treat me? Or should my values be constant, regardless of what that other person is doing? And if I want my values to be constant and not conditional, then I'm not going to get into that, well, I'm going to treat them this way because they're treating me that way. I'm not going to let somebody else dictate my values, is the way I try to think about it in that situation. So incivility, the source of it, I think, can be either because it's deliberate and somebody thinks it's going to be strategically helpful, or somebody is just having a moment of emotional dysregulation.
Thank you.
And let me add to that,
Yes,
this is the Joe Jamel of it all, because I taught at St. Mary's Law School in San Antonio for 9 years, and this was always the counter argument to civility. It was, look at Joe Jamel. Look at Joe Jamel. And Joe Jamel, if you want to look at Joe Jamel, you could go to the internet, YouTube, and it's called Texas-style deposition, where he threatens to beat up the witness, the deponent. And the argument was, and it was great teaching in San Antonio, Texas, where football is God. And when they found out I played college football, students would ask, what happened to the rest of you? And I tell them I used to be much taller and better looking, but none of those are true, actually. So if you research Joe Jamel and you look at what people said about Joe Jamel, they all say the same thing, that he was brilliant, that he was fearless, and number one, pretty much, that he was always well prepared. And that's really what the best lawyers do. We have lawyers in here, and lawyers will tell you that if you're well prepared, that's half the battle, or even more. Also, that he could create incredible rapport with juries. So my argument is always that he was successful not because of incivility, but in spite of incivility, because there are costs. There are major costs to incivility. So one, it increases the cost to our client. If I'm fighting with opposing counsel on everything, I'm not giving them anything in discovery, and they ask me for document requests, they send me document requests or interrogatories, and I just send back objections with no substantive response, then now they're going to have to send me a meet and confer letter to tell me why my responses are deficient. Then I'm going to have to send them a meet and confer letter too. That's costing my client money. And if I keep fighting it all the way to a hearing, It's that motion practice that costs the client money. And then I'm in front of the judge, and now I'm wasting the court's resources on a motion to compel or a motion for sanctions if the other party's bringing that. Instead of the court hearing summary judgment motions and trials, now instead they're hearing things on discovery. So usually when you tell a story about a friend, you're just talking about yourself, but this story actually is about a friend. I was on a civility panel in San Antonio, and one of the other panelists was talking about a case he had, and in that case, opposing counsel said, hey, can you not oppose our motion to continue the trial because my wife is sick? And my friend, who will go unnamed, he said he talked to his client, it wasn't going to prejudice his client, so they said, all right, we're not going to oppose your motion to continue the trial. About a month later, happens again. Trial's coming up, opposing counsel makes the same request for the same reason, his wife is sick, can you not oppose our motion to continue the trial? My friend, again, talks to the client, says, okay, it's not going to prejudice our client, we're not going to oppose the motion. About a month later, same request from same opposing counsel, and this time, the panelist said, no, I think you're trying to take advantage of me because I'm too nice, I think you're playing games, we will oppose your motion, and they did oppose the motion to continue the trial, and the trial was not continued. So on the very first day of trial, opposing counsel gets up after the case is called and says, Your Honor, can we postpone the case until the afternoon so I can attend my wife's funeral? When my friend was telling the story, he didn't look triumphant. He looked devastated. He looked absolutely devastated. Because one of the things with civility is treating others with courtesy, dignity, and respect, hopefully how we'd want to be treated ourselves. So if we were in that position of opposing counsel, we would hope that someone would grant us that request to not oppose the motion. To the point where when I started practicing years ago, I would always try to spend maybe the first 20, 30 minutes when I first talked to opposing counsel about, let's just talk about you and us, okay? What do you like to do outside of the practice of law? Tell me about your family. Tell me where you grew up. And I would share the same with opposing counsel to create that personal rapport so that then we could move forward. And yes, we're going to be battling it out in court or in depositions, but we are going to do it in a civil manner, to the point where one of the opposing counsel that I had a case with for years, we had several cases, and we had a lot of contentious hearings, she called me, she emailed me and said, I'm leaving my firm, can you be a reference for me? Because we were friends. We were friends outside the practice of law. So one of the things you talk about, what can we do to reduce incivility, is first create those personal relationships to the extent we can with opposing counsel, but understand that there are costs. And I'll just read this very quickly. It's a quote from Sandra Day O'Connor, former U.S. Supreme Court Justice, of course, and she said, more civility and greater professionalism can only enhance the pleasure lawyers find in practice, increase the effectiveness of our system of justice, and improve the public's perception of lawyers. So those are just three areas where if you don't have civility, the cost can be very high. I remember a case I had, this is the last story. Again, my older son, he's 17, he calls me a D1 yapper, so I'll stop after this. But every time, it was a pro bono case I had in family law, every time I saw opposing counsel, he said, David, I'm going to get you sanctioned by the court we're in front of, I'm going to get you sanctioned by the Supreme Court of California, I'm going to get you sanctioned by the State Bar of California. Every time I saw him, every time I talked to him on the phone, this is how he greeted me. And finally I said, do you talk to all opposing counsel like this? And he goes, yeah, and I actually like you, David. So when you have that person on the other side, it can make, as you heard Ed talking about at the beginning of the symposium, it can make a lawyer's life miserable. And instead of focusing on the case, now we're focusing on dealing with that obstreperous jerk who's on the other side.
I'll touch on two quick points. One is preparation, as we talked about a little bit before. It's just extremely disrespectful to your adversary, to your own client, to be unprepared. And kind of building off of that is the second point is humility. If and when you do make mistakes, we're all human, we are going to make mistakes in the practice of law. It's simply owning those mistakes, communicating them as soon as possible, and figuring out the best way forward. And civility often also looks like it's the person who calls you and says they're 5 minutes late, and you say, no problem, I look forward to seeing you in 5 minutes, and then 15, 30 minutes later is when they show up. Right? It's just own the mistake that you made and do your best to fix it. Everybody understands a mistake, and you can get over that pretty quickly in most cases. What really irritates people and leads to the problems is when you either try to cover it up or try to minimize it or try to push the fault off onto somebody else.
Thank you. Just quick before we move to our next questions. The argument of zealousness and the idea that zealousness is almost an excuse for incivility. And the older ethical rules used to talk about zealous representation, and those are now gone. Two questions on that. What is the role of zealousness? Is it the excuse that many deem it to be? And do you think it's a good thing that we don't see zealousness anymore specified in the ethical rules?
I think it's still an important component, right? It's the core of it is that idea that our loyalty is to our client. Our role is to do everything we can within the bounds of the facts that we have to work with and the law to help advocate for our client's position. So I still think that concept is going to animate a lot of what lawyers do. I think where it becomes problematic is where it feels like a license for certain extreme behaviors under the guise of zealous advocacy. And so again, kind of getting back to some of the points that David made earlier about attack, but what are you attacking, right? You want to attack the evidence, the other side's position, their interpretation of the law. That is all very different than attacking somebody personally. And I think somebody can be a zealous advocate and still recognize the humanity in another. I deposed, a woman who lost her husband. I feel like I can, who's the opposing party. I feel like I can still say at the beginning, I'm really sorry for your loss, before I get into questions that are trying to undermine her claim for damages, which I have to do for my client. But can I still recognize that there's another human being across from me who has suffered a loss and do my job? I think yes. Maybe not everybody agrees with that, but I think that zealous advocacy does not mean that I have to dismiss the humanity of everybody in the room with me who's not on my side.
Thank you. Professor Grenardo?
So zealous advocacy, it is the argument that when people exhibit incivility, that's typically, here's why I did it. So there was a case in Florida, and I teach sports law and contracts, and I taught professional responsibility for years. Whenever I said there's a case in Florida, usually the students woke up around that point. So there was a case in Florida where an attorney said, okay, you want to take depositions of my witnesses, we're only going to do it at the noisiest Dunkin' Donuts in town. It's the only place you can take your deposition. So finally, opposing counsel said, all right, fine, we'll take the depositions at the noisiest Dunkin' Donuts in town. And when they finally showed up to do the depositions, this lawyer who demanded they be taken there, he came in a t-shirt and shorts to every deposition, and he would play Angry Birds and draw male genitalia during these depositions. And what happened is his firm, he and the firm, got disqualified for incivility. So it's not just that you're going to raise the cost for your client, you're going to waste judicial resources, you're going to make another lawyer's life miserable. You can also lose clients and you can lose cases. Jonathan Schmaby co-wrote an article, he used to be the executive director of the Texas Center for Legal Ethics, on how decision makers, which includes jurors and judges, prefer individuals who are professional, and professionalism and civility. So you may actually lose a case because the decision makers are preferring the lawyer who is civil. Now we have to take this into consideration that the practice of law is one of the few areas of law where it's an adversarial system, where you have two professionals working against each other to achieve their goals. That doesn't happen in a lot of places except sports. Okay, that's probably the best example. You don't see doctors, one who's trying to do a surgery and the other one trying to hit the scalpel out of their hand. Okay, that just doesn't happen. But in sports, again, getting back to how we fight, probably the two best examples I always give are of Mike Singletary, who played for the Chicago Bears, linebacker, Hall of Famer, who was a ferocious hitter, a tough guy, but he fought hard, but he fought fair, versus Bill Romanowski, who played for the Broncos, played for the San Francisco 49ers for years. He was also a linebacker. He was known for spitting on his opponents, punching his opponents, kicking his opponents, and one fellow football player, he broke their eye socket and ended their career. That happened to be his own teammate during a practice. Okay, so there are ways to fight fairly, and there are ways to fight and participate in an uncivil manner.
Yeah, so I think zealous advocacy often is conflated with emotional advocacy or pushing boundaries too much. From my perspective, again, the preparation and the kind of seeing a litigator as cool, calm, collected, and imminently prepared, and kind of owning the moment in that very emotionally self-regulated way is much more powerful than being performative and trying to push the bounds in a way that that ultimately could end up hurting your client and your case, and certainly your credibility.
I will add, though, that not all states have gotten rid of the zealous part in terms of the rules of professional conduct. I know that Ohio has, but still there are some states that have in their preamble that lawyers need to be zealous, but it says also while maintaining courtesy and respect for opposing counsel. And I wasn't in that group that was trying to get zealous or any of its derivatives, zeal or any of its derivatives out of the rules of professional conduct. I really do think lawyers should be zealous advocates. I do think they should fight, but again, I think there's a way to fight.
Thank you very much.
Can I just
Yes, please.
add one other thought? I think sometimes it also requires managing client expectations. I had clients, I would go in and I would shake opposing counsel's hand, and why are you shaking the hand of the enemy? Like, I hate that guy. And but they're pointing to the opposing party, right? Not to I was like, your hatred for the opposing party does not translate up for the lawyers hating each other. Like, I'm going to see that person at a bar association meeting later today, right? So trying to, we want to build their confidence that I am here for you, I am your advocate, but that does not require me to, have the conference room uncomfortably hot for people when they come in from the other party, or not have water available for them, or not shake their hand, or that is not part of my job. Like, your hatred is not my hatred. That's not the business I am in. I'm in the business of being your advocate, of fighting and fighting zealously, but that's not the requirement of my job.
Thank you. I appreciate that. Professor Grenardo, in your article, Why Civility, you make the point that civility isn't just niceness. It affects costs efficiently and even lawyer wellness. If you had to pick one concrete way incivility most directly harms clients, what would you select?
Well, we've talked about a number of those already. What I'd like to point out, and we're going to get to one of my thoughts on mandatory civility, because I believe that is the answer here, is lawyer wellness, health and wellness. And talking to the disciplinary counsel, the chief disciplinary counsel from some of these states, they talk about when you have a mandatory civility rule and there is some type of outburst, and opposing counsel or somebody, the opposing party, makes a complaint against the lawyer, it allows disciplinary counsel to call up that person and say, what's really going on here? And a lot of times it's, well, you know what, I lost my only paralegal that works for me, they left. I just lost my father. I am having substance and alcohol misuse issues. I have anger management issues. So it's not that mandatory civility requires everyone to get in trouble and punished. When that happens, then disciplinary counsel can simply say, all right, we're going to send you to Lawyers Concerned for Lawyers, or a lawyer's assistance program, or an anger management program, or an office management program. So these are things that can be done when you have mandatory civility. And the other thing, and we're going to hear, I believe, in the second panel from a Supreme Court justice from Michigan. Michigan is one of those states. there are cases out of Michigan, again, as a mandatory civility state, where they say specifically isolated incidents of incivility don't even rise to a level of violating their civility rules. Because the practice of law is very passionate, and you may have somebody's life on the line, their business on the line, it's the worst day of their lives, or the worst part of their lives being part of this lawsuit. And there was a case, Grievous Administrator versus Szabo, S-Z-A-B-O, where a lawyer was part of a very contentious hearing, and opposing counsel had showed up an hour and a half late to that hearing. And this lawyer, who the grievance was filed against, he called opposing counsel effing a-hole multiple times. And by coincidence, that's my family's nickname for me as well. So, but he called opposing counsel effing a-hole multiple times and challenged opposing counsel to a fight. And the court said, the opinion said, that does not rise to the level of violating our civility rule, because we understand that the practice of law is difficult and passionate and hard. So in thinking about if we're going to have mandatory civility rules, it's not that I didn't open the door for someone, now I'm going to get disbarred. That doesn't happen. The only state that me and my research assistants can find where anyone was disbarred for consistent and persistent uncivil conduct, and there were 2 lawyers, but they were several hearings, never taking responsibility for what they'd done. On the count of 3, let's say that state. 1, 2, Florida. But that was the only instance, because usually the reprimand is a private reprimand, sometimes a public reprimand. There's a lot of slapping cases. Unfortunately, a lot of lawyers slapping each other. Usually it's a suspension, but a lot of times they just dismiss it, or they just call up the counsel and say, what's going on? Please knock it off. Can we get you some other type of help?
Thank you. Professor Rigertas, you argue that lawyers should routinely assess the effects of their conduct on third parties. In modern litigation, what are the hardest third-party interests for the lawyers to keep in view as it relates to jurors, witnesses, or someone else?
I have different answers on different days for that. So, but I think if we want to think about the interest of the public, that's probably the hardest one to keep in mind when you are in the throes of your particular litigation in your case. But if we want to think about the overall public and the role of lawyers in the system and maintaining the integrity and trust in the system, the rule of law only functions if people believe in it. Right? And if people believe in the integrity of the institutions and the people involved in those institutions. So I think that wider lens is easy to forget when we're in the throes of our particular litigation, that what we are doing is not just about our clients, but it is also about how we are guarding the rule of law and how we are maintaining trust and respect for the institutions in which we are involved as lawyers. So I think that's probably the hardest one to keep in the field of view when we're sort of in the trenches.
Thank you. Professor Seger, when courts and bars confront incivility, do you think consequences should be primarily educational, disciplinary, reputational, and what produces real behavior change?
Yeah, I think thinking educationally, we should go back to what Dean Zitlow talked about, going back to law school and starting to teach there and not have it necessarily be a consequence for a violation of our rules, but part of that culture building. And so I know having, being a graduate of the University of Toledo, all the great things they do here to make sure that the students who graduate from Toledo ultimately fit in with the Toledo bar, which is an extremely civil and welcoming bar. And it's similar in Dayton with the University of Dayton School of Law, where we have students come in and take an oath of professionalism. They have judges come in and talk about civility. And so there's training from the beginning that I think is really important. So it's not always reactionary, but building this culture. I would hope as it relates to consequences that reputational harm for incivility would be enough for most attorneys. And so it's my own personal belief and thought that that is kind of the biggest deterrent when it comes to incivility is lawyers only want to work with other lawyers, employ other lawyers, be friends with and colleagues with other lawyers who act properly under the circumstances, and they know that they can trust to act properly in those really difficult circumstances. And so I would like to think that that potential economic self-interest for most lawyers would be enough to build that up, and then knowing if you do something and you do affect your own reputation because of incivility, and it has a negative aspect on your reputation, it might be something from your employer, discussion or like that, or it might be, losing your job. We see that a lot too, and that can obviously be, just the threat of that is enough to make most people act properly. But then ultimately, as we've talked about, there do need to be real consequences from the bench and from the grievance committees when things go too far. So what I'd like to think about it as is kind of like a blanketed tier approach in terms of creating the culture and then ultimately reacting if necessary.
Thank you. So I guess in a broad context, what's the easiest part of civility? We've talked about incivility and the difficulties of civility. What's the easiest aspect of civility?
Easiest? I mean, it's the easiest part of it is talking about it, is putting it in oaths and watching these CLEs and saying, yeah, I'm going to do it, and then some people still don't. So the hardest part of incivility is responding to incivility. And you've heard a lot of great techniques on how to respond to incivility, but certainly when you respond with more incivility, it just makes the situation worse. But again, I think it's easy to talk about civility. It's fun to watch the egregious actions of lawyers and say, well, that's not me. But it can also be, incivility can be subtle as well. And just to get back to a couple of the points that were brought up here earlier about clients and law students and how do we integrate them into the profession, that's one of the biggest issues that we have. I've had law students who sincerely believe that when they get to law school, if they're first-generation lawyers or even not first-generation, they sincerely believe that they need to be jerks in order to be successful attorneys. And certainly clients have believed that as well. So part of it is disabusing clients and law students of that notion that you have to be a jerk to be successful. In fact, you can be more successful as a civil attorney, acting with civility. I talked to a number of judges in Pennsylvania, and the biggest issue that those judges had were actually with pro se parties. Individuals who were representing themselves. They were some of the most uncivil individuals that judges had to deal with. And the judges would consistently ask, why are you so uncivil? And the pro se parties would say, this is what I think lawyers do, because this is what I've seen on TV, in movies, and in the media. So, and that's what law students see, and that's what clients see. So that's what they then believe is the best way to advocate for someone. And they don't recognize the incredible costs that come with that, the reputational costs, the cost to the client, the cost to the wasting judicial resources, and potentially upsetting a judge either consciously or subconsciously. If I'm fighting something I shouldn't be, like the example I gave earlier, how is the judge going to rule against me? Again, either thinking, I can't believe this lawyer opposed that motion or is fighting on this. And it could be consciously, it could be subconsciously.
Now, in that regard, we've talked about this a little bit before, tactical incivility or strategic incivility. Is that a misnomer? Is there, or is there a, I mean, really, or is there a role for it? I know we've already talked about zealousness, but, being rude for a purpose.
I don't think it should have a role. I think there are more effective ways for us to do our job. That being said, can it be effective sometimes? Probably. So that's probably why some people do it sometimes. The eye rolling during the deposition, right, that the opposing counsel might do, maybe that does throw somebody off. The, interrupting the flow of questioning at a deposition just for the purpose of trying to throw somebody off is incivility. Maybe it does throw that person off. So people think that this is good. I'm throwing them off, and they're not keeping up with their line of questioning. But I don't think that's what we should be doing. If I think that their questioning isn't proper, then I can make my proper objections. But if I'm just making objections for the point of interrupting, that has nothing to do with the facts or the law, right? So my objections should relate to those things, and I should be prepared and have my own questions to ask to try to undermine the questioning of the other person. So I don't think it has a role. I have a dream sometimes, you know how like you go to the doctor, you get like your HIPAA form, although now they just have you sign something that pretends that you got a HIPAA form. Or, you know, when I get certain things done in my house, like a new roof or something, they're required to give me some consumer rights thing. Like sometimes I think, should all lawyers, when you get a client, have like a state standardized thing to give them about this is what you can and can't expect from your lawyer? And part of that would include some of the behaviors that they might expect so that we are educating the entire public whenever they take on a client or whenever they have that lawyer-client relationship formed about this is what you can and can't expect. So sometimes I wonder if that might help.
And I agree, and I think that's a wonderful segue into really the last aspect that we're looking at is really going forward from an educational point of view, from a professional point of view. You know, how do we inculcate the greater aspects of civility to lawyers entering the profession, to young lawyers, even to lawyers who have that need a refresher in that regard as to what it means to be civil in that regard. And I guess in that regard, from a more practical aspect, what should we be looking at going forward from a rule-based aspect? Professor Seger, in your upcoming article, Viral Temptations, you discuss how quickly online conduct can collide with ethical duties. Trial publicity, statements about judges, and more. What's the most common digital trap that you think well-intentioned lawyers fall into? So again, not with that idea of tactical civility, but almost incivility by accident.
Yeah, I think it is that speed trap mixed with the kind of the idea that when we speak online that maybe we're speaking just our personal thoughts, but we're overlooking the fact that we are always representing the bar, we are always members of we are representatives of the court, right? And we are always under these obligations no matter when and where we are speaking. And so when you put those two things together and even the potential for anonymity and things like that, or at least kind of feeling like a comment here or something like that on social media, even if I know it's improper, it goes beyond what maybe I normally would do, it'll just kind of get lost in the shuffle somewhere. And so it's kind of this feeling that online communication is different. And of course it is, but it's not so different that we shouldn't stop and think for ourselves, would I say this to a person in real life? The feeling is just different behind a keyboard than it is when we're speaking with somebody personally. And that, I think, creates in our mind some sort of a justification or at least a shortcut to say, I don't need to go through that process and I can just hit enter, and I don't see what consequences might come from this behavior.
Thank you. Professor Rigertas, in your article, Demonstrating Civility, you argued that civility should be a learning outcome and that law students should not just describe it, but more or less live that. What does demonstrating civility look like to you in an accessible way? What behaviors can we actually measure?
Yeah, so when the ABA changed some of its rules years ago and required law schools to articulate learning outcomes that they wanted, David's school was kind enough to create a database of these different learning outcomes. And so I was curious, I started to search it to see how many schools had adopted outcomes that related to civility, or sometimes it was respect or courtesy. I think when law schools were first charged with articulating learning outcomes, there might have been a tendency to articulate a lot of great things, and then the ABA was like, now you need to assess them. And so there was sort of some concern that maybe we would pull back now that we're like, oh, we have to figure out if we're really doing the things that we said that we're doing. So I was just curious in terms of civility, respect, courtesy, what types of learning outcomes were being adopted. And it looked like there were about 30 schools that had adopted some type of learning outcome with respect to civility. And some of them said we were looking for the students to understand civility, and others said we were looking for them to demonstrate civility. So I was interested in kind of how we might think about those two different ways to approach it. So for demonstrating civility, a couple of thoughts that I have for the law school context. One, I think for students who are in externships or in clinical settings, they are doing work where their professors or their supervisors, if they're in an externship, can assess what they are doing in the workplace or in the clinic. And if, for example, that jurisdiction has, an aspirational civility code, that could form a basis for a rubric for the types of behaviors that they're seeing that could be assessed. There could also be ways to assess that aren't individualized. So for example, Southern Illinois University, I don't know if they're still doing it, but at one point they had the 1L class as part of their orientation they had to draft collectively a code of conduct or code of professionalism for their incoming class. So you could do something like that and ask them to include what would civility look like in the law school setting in terms of how law students interact with each other. And then you could do a survey at the end of the year and ask the students to kind of rate, did you, witness an example of somebody, doing whatever they had put in their code, cutting somebody off during discussion in class or attacking somebody personally in class. You could ask them whether you ever did or whether you ever, observed that. So that could be another way, on sort of a group basis for people to think about what they are observing and what kind of community they are trying to create in the law school. And just doing the survey may also serve as like a reminder of, oh yeah, we talked about this, we agreed this is how we want to behave as a community. So those are just some initial thoughts I have.
And it seems to kind of, I always talk to my daughter about small acts of kindness and the idea that civility is something that is incremental. And it sounds like your approach sort of highlights that. I mean, do you see civility being taught in every law school class? I mean, professional responsibility is sort of, seems easy to jump to mind, but, torts, contracts, constitutional law.
I put it in my syllabus for whatever class I'm teaching. When I have my learning outcomes, I have the substance of what we're covering, but I also have professionalism learning outcomes that every classroom is a microcosm of our, gives us an opportunity to have respectful dialogue about topics that we're going to disagree about in class. So I do include it as one of my objectives, even though I'm not grading it. It is listed in my learning outcomes regardless of what I'm teaching.
Thank you. Professor Grenardo, you've argued that more jurisdictions should move toward a mandatory civility. Looking forward, do you think mandatory civility rules will become more necessary because of digital practice, as Professor Seger has mentioned, or will the profession overcorrect in a way that has a potentiality of chilling advocacy?
Those are great questions. So first of all, we've seen studies, 2023, the ABA had a study. 85% of Americans believe that incivility has gotten worse over the last 10 years. And that was 2023. And I always tell my law students, there's nothing that brings our country closer together than a presidential election. So after that, there's actually more data that we become more polarized, more uncivil. So I have argued, and I continue to argue for mandatory civility, and here are the rules that I've argued for. And the first one is that lawyers cannot make personally disparaging remarks about others involved in the legal process. And this is very similar to what Michigan's rule of professional conduct includes as their civility rule. And I include, it's not just, so part of it is based on somebody's idiosyncratic personality, whatever it is, the way they look. So my mom was born and raised in Poland. My dad was born and raised in Guyana. And that's why I have these weird looking eyebrows, okay? Are you guys staring now at my eyebrows? Okay. Let the record show they were staring. Okay, thank you. So if every time before a deposition, a Opposing counsel says, David, you got weird eyebrows, you got strange eyebrows, you got weird eyebrows. Eventually that would become annoying, all right? But also in that rule, just like Michigan has, is that in particular, you can't bring about, or you can't personally disparage somebody based on any type of protected characteristic. So their race, gender, ethnicity, any of those types of things. So, and we'll get back to that, but that's rule number one. And you can't disparage another party's work product, okay? So what that doesn't do, though, it doesn't prevent me from challenging a client's or witness's credibility on the stand or trying to show that they're biased. It doesn't mean that, okay? And also it doesn't mean in a brief saying the other party is, their arguments are meritless for these reasons. In a 2023 case, in front of the Supreme Court, an attorney wrote in his brief, opposing counsel's brief is a hot mess. I'm not sure if that helped the Supreme Court justices figure out what was wrong with opposing counsel's brief, but then it made the legal profession look like we're the Real Housewives of whatever city they're in now, which I think is every city. So, but that's the first rule. Another rule, don't make personally disparaging remarks. Another rule is try to work with opposing counsel on scheduling, on hearings, depositions, and if something comes up you have to cancel, tell them as soon as you can. Another one is grant reasonable extensions if it will not prejudice your client, okay, which I always did. I asked the client, can we grant this? Absolutely. So that's how I practice. Another one, which transactional lawyers like, and I like this also as a litigator writing settlement agreements, if you make a change in a document, then you will tell the other side the change that you have made so that you're not sneaking provisions in there. And finally, the last proposed mandatory civility rule is if we've reached a verbal agreement and I'm writing it down, I'll write it down accurately. Those are the 5 rules. And when we talk about civility, we're typically talking about aspirational. Like this is the high standard, the high conduct we want from lawyers. This is a very low bar. This is a very low bar. You will not personally disparage someone in the legal process. You will try to work with them on scheduling. You will grant them reasonable extensions when it won't hurt your client. You'll tell the opposing party if you've made a change in a document, and you will write down verbal agreements accurately. And I've been arguing for mandatory civility for years, and it gets more saddening every time I do it. And I tell my older son, he says, how long have you been arguing for mandatory civility? I said, for 15 years. And he says, how many states have adopted it since you've been arguing? And I said, I'm not putting any more money on your debit card. So I will say this, though. Ohio is probably closer than a number of other states to actually adopting some type of civility rule. First of all, in Rule 1.2 of the Ohio Rules of Professional Conduct, it says a lawyer does not violate this rule by acceding to requests of opposing counsel that do not prejudice the rights of the client, being punctual and fulfilling all professional commitments, avoiding offensive tactics, and treating with courtesy and consideration all persons involved in the legal process. And then the comment to that goes into saying that specifically, punctuality, the avoidance of offensive tactics, and the treating of all persons with courtesy are viewed as essential components of professionalism and civility, and their breach may not be required by the client as part of the representation. So the rules right now actually say it is not a violation of the rules, basically, to act with civility. All that would need to be done is to say, in order to fulfill this rule, you must do these things. You must accede to requests of opposing counsel that do not prejudice the rights of clients. You must be punctual in fulfilling all professional commitments. You must avoid offensive tactics, and you must treat with courtesy and consideration all persons involved in the legal process. You also have the Supreme Court rules for the government of the Bar of Ohio. This is under number 4, Ohio Rule 4 for the government of the bar. It is the duty of the lawyer to maintain a respectful attitude toward the courts, not for the sake of the temporary incumbent of the judicial office, but for the maintenance of its supreme importance. All you have to do is add language. It is the duty of the lawyer to maintain a respectful attitude toward the courts and all individuals involved in the legal process. That's all that would have to be done in order to make civility mandatory in Ohio. And it's very similar. It's very similar to what New Jersey did. They really snuck it into their Rule 3.2. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client, which is what a lot of jurisdictions have. But then they added, and shall treat with courtesy and consideration all persons involved in the legal process. So Ohio is very close. If there are people in here who have the ability to talk to the Supreme Court of Ohio or talk to the folks, the disciplinary council, I would love to see mandatory civility adopted in Ohio, especially because it sounds like the Toledo bar is already practicing civility, already leads with civility. And it wouldn't be that far of a leap then to make sure that all bars in Ohio are fulfilling that. Now I will just say this, because it is an issue that we're going to talk about, or that we talked about previously in preparing for this, which was, does it chill advocacy? Does it chill advocacy? And I am responding right now to a law professor who has written an article saying that civility is racist and oppressive. Okay, so some of you are going like this, and that's what I did when I read the article too. And he specifically called out my efforts on civility and my civility rules. And what this has turned into is, it's kind of like a rap battle. This is a little bit like Drake and Kendrick Lamar, except one, the difference is one, it takes a lot longer to respond, okay, because now it's taking forever to finally finish the article. And two, this is the important one, no one cares. All right. That first rule about mandatory civility, it's actually there, and he doesn't even address my civility rules, but he says they're racist and oppressive. And I get it in terms of, if we're just talking about civility in the etymology of the word, where did it come from, to civilize? If we're talking about trying to make people act and talk and behave in a certain way, okay, I understand that's bad. But if we're doing it in the context, talking about civility in the context of lawyer conduct, and we have specific rules. Remember the rules I put out there: don't disparage someone personally. Try to work with them on scheduling. Grant reasonable extensions. Tell them where you've made a change in a document. Write down agreements accurately. None of that is racist or oppressive. In fact, the studies that have been done, and I hate when people say studies show and they don't tell you what studies, but in several of my articles on mandatory civility, if you want to read them, you'll be the third person besides my mom and my grandma to read those articles, so that would be great. I'm kidding. My mom doesn't read my stuff. But in there, the studies, not just in the legal profession, but also in the workforce in general, is that racial minorities and women and other marginalized groups, historically underrepresented lawyers, are typically the victims of incivility. That was shown in the California Civility Task Force that was done in 2021. Again, that those groups are typically the victims of incivility. That was the same thing they found in a recent study in 2024, the Illinois Supreme Court on Professionalism. They were looking at bullying, which is a form of incivility, and they again found that those marginalized groups were typically the victims of bullying. So it's not racist. It actually will protect those individuals who are typically the targets of racism. And last thing on this, on that bullying study in Illinois, they looked at who were the bullies. And by the way, they estimated that around 10,000 lawyers in Illinois alone have left their jobs due to bullying. Okay, that's a really high number. And 33% of the bullies were identified as someone outside the lawyer's organization, so most likely opposing counsel. 31% of the bullies were identified as senior attorneys or supervising attorneys in that own lawyer's firm or entity. So when we talk about one of the ways to overcome incivility, it starts with mentoring. It starts with coaching. It starts with modeling that by people who are doing it right. And 14%, unfortunately, the bullies were identified as judges. I know we're going to have a couple judges talk today who I know are not bullies, but we have been, if you've practiced long enough, you've been in front of a judge who has been uncivil. One judge asked me, I think this was a good question, have you gone to law school? And I actually had been to law school by that point. So it happens. But the importance, and it sounds like the University of Toledo College of Law takes a lot of pride in the type of lawyers that they create, and then Toledo in itself does a great job of making sure that the norm, the standard, is civility. And that's something to be very proud of, because that's not how it works all across the country.
Well, in that regard, Professor Rigertas, if you could change one thing about legal education to improve professionalism and practice, what would be the first thing you would change, and why?
I think I would include something in the educational program about having difficult conversations with people. I feel like it's a little bit of a lost skill, and maybe my perception isn't totally correct, but I do feel like my students over the last 20 years are talking less to each other when they're not in agreement. And the way that our current world is set up, it is really easy to just hunker down in one's tribe in a way that I think we couldn't do. Like when I was growing up, everything, I didn't have like an online community I could go to, right? My community were the kids in the neighborhood. I wasn't on Roblox. I had to figure out how to do kick the can with everybody in the neighborhood, like whether I liked them or not. And we were put in those positions more where we had to figure out how to be in community with people in 3D, where now, and we couldn't pick our news source. We were all sitting down to watch Walter Cronkite or whoever. And so it's much easier for us to find our tribal lane and get in it and stay in it and not figure out how to communicate well with other people. Or often there's that, the online advocacy. We want to try to persuade somebody that their position is wrong by calling them an idiot or something, and it's a person we have no relationship with. Where, as you were saying with, opposing counsel, if you can form a bit of a relationship with somebody, there's probably some common ground you can find, and then you can start to have those more difficult conversations and talk about, no, my political opponent is not my enemy. I want to understand where they're coming from, because how do I persuade, right? If lawyers are ultimately persuaders, you can't persuade somebody when you don't understand where they're coming from. And we're so isolated often from people that we feel, that have different positions from us. We're not communicating in a way where we can persuade. Now, some of my students will say to me things, and I completely understand, like, I feel like that person's position is dehumanizing me, is wanting me to not exist, right? And if somebody feels that way, I can understand why that might not be a person that they want to engage in dialogue with. I get that that is hard. But for a lot of us, it's not that level. There are just things that we could talk about, and we can, instead of immediately trying to persuade, to first understand where the other person is coming from, I think is a more helpful way. So I wouldn't limit that to law school. I would like to see that in K through 12.
No, I appreciate that too. Professor Seger, looking ahead to the next era of professionalism, so what do you see ahead as it relates to civility, both broadly and in an enforcement, if you think that that's appropriate?
Yeah, and as it relates to technology specifically, obviously it's not going to go away. It's only going to continue to ramp up. And so one thing that I do want to think and talk about for a moment is just artificial intelligence and how that is going to affect, again, the way that we interact with each other and the way that we practice law. We've seen far too many cases now where we have ghost citations, made up hallucinated citations in briefs, and that's a form of incivility, of course, right? It's the lack of preparation, it's the lack of respect for your client and your court. So it's not only a competence issue, it's certainly a civility issue as well. So looking to think about how to make sure that you are, again, prepared and competent to use any technology as it relates to artificial intelligence or anything else that you're using to aid in your practice before you do so. That's also going to be an important form of civility moving forward. And also, again, owning your mistakes as it relates to those hallucinations. We've seen in the Southern District of Ohio recently an attorney sanctioned and a case actually dismissed because there were hallucinations in a brief. It was pointed out by opposing counsel, as it should be. The court, requested a refiling of that brief, and those hallucinations and new ones came back again and again. And the same thing just happened in a Southern District of California case as well. And so it's kind of taking the time to make sure that, if you are feeling overworked, if you're feeling like unprepared, you need to have the wherewithal to make sure that you're slowing yourself down and asking for the help, being humble and having that humility in the moment to say that maybe I can't handle this right now and I need to work through this in some other way.
Thank you very much. Thank you all. This has been a wonderful discussion. I'm glad that I've been able to participate in it with you. I think at this point we can ask our audience if they have particular questions on civility. Oh, thank you, Ms. Welch.
This question is for Professor Grenardo specifically, although I'd welcome any responses. So Ohio does have some semblance of mandatory civility, as you know, in our attorney oath, in which attorneys, in their capacity as officers of the court, that we will conduct ourselves with dignity and civility. And yet, we also know that the Ohio Supreme Court recently amended its rules of professional conduct and rules of judicial conduct that in some ways erode the traditional First Amendment limits on attorneys' free speech, specifically Ohio Rule of Professional Conduct 8.6 and Rule 1.4 Judicial Conduct. How do you respond to Ohio's seeming criticism that mandatory civility limits First Amendment rights in an impermissible way?
Great question. And that is also part of this article that I'm looking at. And it looks at basically the history of lawyer regulation and free speech. And going through it, I talk about how if you look at that history, and there's some Supreme Court cases on it, but not particularly the Gentile case, although it's a splintered case, it does talk about how you can regulate lawyer speech. And lawyer speech is not unlimited, but there are certain spots where lawyers should be able to, and they need to be able to talk. So if they're talking about the rule of law, if they are criticizing the government for failing to abide by the rule of law, or they're criticizing how the legal system works, those should absolutely be protected by the First Amendment. And certainly if they're talking about anything that constitutes political speech, then that would be given one of the highest forms of protection. But legal scholars who are professional responsibility scholars, who are First Amendment scholars, they seem to agree that if statements are made that are simply insults, that are simply meant to waste time, waste the court's time, waste opposing counsel's time, then those don't rise to the level of protected speech. So there's a very famous case out of Michigan, and the Jeffrey Feiger case, where there was a case on appeal, and there were 3 appellate judges who ruled against his client, and partly based on his behavior, and he called on his radio show, he called them Hitler and Goebbels, and then whoever Hitler's girlfriend was. And then he proceeded to say that those judges should shove something up their rear ends. And he gave a couple of examples of possibilities. And the Michigan Supreme Court, looking at that, said, look, we have these civility rules, and it's to, 1, try to maintain the type of folks that we have coming into the bar. Make sure that they're actually going to try to promote justice, trying to make sure that they're not going to try to do things that are prejudicial to the administration of justice, and also somewhat to protect the judges against just attacks. Now, if it's some type of fair criticism that the judge should have applied this 3-part test and just completely left off the second part, or even if someone says, I think that judge is biased, there's a case in California where they talked about, I think this judge is biased, I think this judge doesn't like Jewish people, then, okay, then is there a basis for that? If there's a basis for that and you're making some type of credible criticism, then that would be protected. But if it's simply, you're a jerk, you're an a-hole, you're awful, you're ugly, whatever the case may be, that doesn't fall under any type of protected speech. So, again, part of it, if it is a mandatory civility rule, and I don't know if Ohio can use the oath as a basis for sanctions. I know a lot of states specifically say they can't do that, so I'm not sure if Ohio, if Ohio does mandate civility, I will take full credit for that. I'm kidding, I won't, but I will look into that. So, but again, we're trying to figure out what is this speech? Is it the type of speech that should be protected versus this is simply trying to annoy, harass, or terrorize another lawyer? Great question.
Hi there. My question is about, it's from the Michigan Supreme Court a few years ago adopted a new rule of civility that does not permit intentional misgendering of a witness, a client, certainly, opposing counsel, and in one of the concurrences to that order, one justice wrote that some judges may have religious reservations about this, right? Or some attorneys certainly may have religious reservations about this. And her response was simple: call them plaintiff, defendant, or counsel. Where do you think that, like, these sort of religious reservations, specifically around like gender identity, exist? I think it's important that courts aren't intentionally misgendering, and that rule actually came as a result of an appellate judge in Michigan misgendering a party in front of him, and that certainly doesn't look like an unbiased, uninterested, neutral party sitting there adjudicating the case.
I guess my initial thought is if we're going from the principle of we're trying to respect people in the court, then respecting somebody would be using the gender pronouns that they have chosen. Now, how that ties into a religious belief, not having done like a deep dive thought about that, my initial thought is, when you are in the role of the judge, the law has to come first. And if the law requires civility and respect, then that would trump, is my initial thought.
Yeah, those would be my thoughts as well, that the definition that I use, again, is treating others with courtesy, dignity, and respect, and demonstrating cooperation, honesty, and restraint. And I can talk from a Catholic school, Catholic law school, that the first week of classes in orientation, we talk about human dignity. And we talk about it from a Catholic perspective, from a Jewish perspective, from a Muslim perspective, Hindu and Buddhist, as well as a secular perspective. And we are trying to make the point that all those different approaches, in one way or the other, require that we treat each other with dignity and respect. So, and that's always my fallback. I grew up Catholic, still Catholic, and my fallback is always the two greatest commandments is love God and love your neighbor. So I always, that's where I go to when I'm not sure what I should do. I try to fall back on that. So the misgendering, and I don't know if intent, I'd have to see what the rule is. Does it look at intent? If a judge is doing it unintentionally and they are not trying to offend someone, how does that play into it? If they're intentionally doing it, and you're saying also if it's being done based on religious grounds, I would just say, you can still say just plaintiff or defendant. And still, in that way, be treating someone with courtesy, dignity, and respect. Yeah, these are tough questions that I wish Nick would have answered.
Well, you could probably see how uncomfortable I was in the moment, because it is such a difficult question as we think about respecting people, but also being true to our own personally held beliefs. But I agree ultimately that we can't hide behind religion in a way that violates the rules of civility and that ultimately leads to bad outcomes in court. I would also kind of what you've been touching on, think a little bit more about your belief system if you think that is something that you really need to do, but that's more of a moral judgment for me that probably I should not share.
Thank you. By just sheer professionalism, is it fair to say that attorneys and jurists should, in fact, be held to a higher standard of civility compared to, let's say, a legislative body? A thought that comes to mind is look at the British system, where we have free-for-alls in the Parliament versus the very elegant and reserved manner in which barristers approach their profession.
Lawyers are leaders, so I think it is, and we have an important role in, a branch of government. So I think holding us to a higher standard than the general public makes sense. Mm-hmm. There are a lot of lawyers who are members of legislatures, and I don't know that the brawl, free-for-all process is effective, and I think it would be helpful particularly to the extent that lawyers are in that other role in a legislature, that they try to raise the level of debate. I mean, I feel like so much of our debate right now is not about the ideas, but about name-calling and othering. So I would also like to see those deliberative bodies focus more on debating the ideas and not villainizing each other on a personal level. I think we would all be better off.
Oh, go ahead.
No.
I was going to say that's a great question, and the preamble of the rules of professional conduct also say that we are representatives of the legal system, representatives of the court, officers of the court. So I absolutely believe that lawyers and jurists should be held to a much, much higher standard and not devolve our behavior into whatever society is doing, because then a lot of times this is where we get into clients and others believing that whoever has the loudest, most obnoxious lawyer, that's who wins, as opposed to the cases are decided on the merits.
And I would also just add that as lawyers, and I think that absolutely there should be a different standard, that we should be held to a higher standard because we're looking at the administration of justice, the correct outcome through the litigation process, whereas legislators have a very different goal, and that's looking at and trying to convince the general public to essentially vote for them and support their policies. And so when you look at it that way, the purpose of the job is also different. Of course, there's overlap when lawyers go into that field, and we can have a larger discussion on what they should ultimately do to try to balance that. But I do think when we're going through and trying to make sure that the system works properly and leads to just outcomes, that's a very different goal than trying to convince society as a whole that our policies are the best.
And the only other thing I would add for the students is there's not a big line between your personal and your professional reputation. So you may not be wearing your lawyer hat at all times, but your reputation is being developed at all times. So, think about that in terms of your online presence, other walks of life, things that you may be doing where you might not be actually wearing your lawyer hat in that moment. You are still, in some respects, always developing your professional reputation. So just keep that in mind.
I guess this is also the part of the show where I say I do have lawyers who are friends in Florida. There are very good lawyers there as well, and in all these states. And I think Ed is going to be coming to give us the hook here. So I wanted to say thank you for having us. Thank you for having me. It's been a wonderful time. Thank you.
Yes.
Yeah, thank you.
Okay, we'll have a break from 10:40 to 10:50, and then the next panel will begin in here at 10:50, so be in here there. Then, thank you.
which is probably a good thing also.
I'm so pleased and honored to have the panelists who are here for this panel, these amazing judges. And I'm going to start out by introducing them briefly, and then Judge Knepp's going to take over, and he's going to be sort of the moderator and participant. So we'll start actually with Judge Knepp, the Honorable James Knepp II, confirmed by the United States Senate as District Judge for the Northern District of Ohio, previously having served as a magistrate judge in the same court for over 10 years, grew up on a farm near Akron, graduate of Mount Union College and BGSU, and after a brief career in broadcasting, which he sometimes brings to College of Law events as a DJ, he attended the University of Toledo College of Law, so we're very proud to have him as our alumni. He began his legal career as a law clerk with Judge Potter, and then worked for 16 years in the law firm Robinson, Curfey, and O'Connell. Judge Knepp is active in the Toledo community, serving as past longtime board member of Legal Aid of Western Ohio and Able, and is past president of the Toledo Legal Aid Society. He's an amazing participant in the Toledo law community, both the college and the community at large, and it's really great to have him here today.
Thanks, Steve.
I am extremely honored to have here today the Chief, as I like to call her, the Honorable Chief Justice Sharon Kennedy of the Ohio Supreme Court. Justice Kennedy was elected Chief Justice of the Supreme Court of Ohio in November 2022, becoming the 11th Chief Justice and the second woman to hold the position. She joined the court as a justice in 2012 and was reelected for full terms in 2014 and 2020. Before her Supreme Court tenure, she served at the Butler County Court of Common Pleas, where she improved case management and championed family law reforms. She also led financial initiatives during economic challenges in Butler County. Her career began as a police officer. She later practiced law, served as a magistrate, and worked as special counsel for the Ohio Attorney General. She has received numerous awards for her service and leadership throughout her career, and I'm going to take a point of personal privilege that one of the joys of my job as dean here at the College of Law is that I have the opportunity to meet regularly with Chief Kennedy, and she's just a wonderful person, an amazing dynamic leader, and a wonderful person to work with. And coming from across the border, the Honorable Justice Elizabeth Welch of the Michigan Supreme Court. We're excited to have her here across the border here in Ohio today. She joined the Michigan Supreme Court on January 1st, 2021. She currently serves on the Michigan Judicial Council and as the Justice Liaison to Judicial Information Services. She also co-chairs the Commission on Diversity, Equity, and Inclusion, recently changed to the Commission on Fairness and Public Trust in the Judiciary. Previously, she was a liaison to the Michigan Judicial Institute, served on committees for the Justice for All Commission. She received her law degree from Ohio State University and her undergraduate degree from Penn State University. She has a long history of serving professional and nonprofit boards, currently the Vice President of the Steelcase Foundation and Ambassador for the Grand Valley University Foundation. She has served as a trustee on her local school board and worked for more than 15 years on public education and voting rights policy. And she and her husband, Brian, live in Grand Rapids and have 4 adult children. So it's really great to have the 3 of you here today, clearly dedicated not only to the law, but and in that way into public service in so many ways. And I'm looking forward to hearing what you have to say to us today. Thank you.
Thanks, Dean. I always hesitate to be a moderator because I'm not very moderate about anything. I tend to mix it up a little bit. But I'm recalling the eve before my Senate confirmation hearing, which that's if you ever want to see your life pass before your eyes, think about appearing before the Senate Judiciary Committee. The evening before my Senate Judiciary Committee hearing, my vetter, who is the person who was from the Department of Justice, whose job was to, in the first instance, find anything bad she could find about me so they wouldn't nominate me, but once I got nominated, then her job became to get me through the process, along with a bunch of her colleagues. And she said words that I thought so much of, I actually have them on a coffee cup on my desk. She said to me, "Judge, I need you to be a little less you tomorrow." And I'm thinking, well, that's a hell of a thing to say, but she was right. So I looked at that coffee cup before I came here today, and I'm going to do my best to be a little less me and a little bit more of a moderator, and hopefully we can have a discussion. It's a little tough to follow the panel this morning because they did such a good job of covering a lot of things. I found myself one by one crossing off notes that I had made that I wanted to scintillate you all with, including but not limited to my sports analogy, which might make its way back in anyway. But I would like to hear from the justices, and we'll start with you, Chief. Just sort of fly us over. What does civility mean to you, and why do we care, and what does it mean, and why do we care?
Well, good morning, and thank you for the opportunity to be with you today. Thank you, Dean, for that kind introduction, and I look forward to our quarterly meetings. I think that civility matters because it is really important for society, not just the legal profession, but it is a pathway to being able to have a public conversation about difficult issues. As Speaker John Boehner used to say, we can disagree, but we don't need to be disagreeable. So for me, it is a societal matter, and I think that's the relevancy. In the law, I think it is expected when you serve as a lawyer and or a jurist that you have a responsibility to conduct yourself in a manner that allows the arguments to be heard, not you. And when you are faced with difficult topics, conversations, something that we talk about in our quarterly meetings, is helping students have those difficult conversations without having the shouting match. And to me, that becomes very important because if it becomes about you, it's no longer about your client. So I was in a trial court for 14 years, saw the good, the bad, the ugly, and to me, that civility is really the conversation for all of society.
Thanks. Justice Welch?
I echo a lot of what the Chief Justice said. So there's really 2 parts to it. One is effectiveness as an attorney and what actually works as an advocate. And I think those of us who have a little more years of practice behind us, I was in the litigation trenches for about 15 years. And if you look at who's effective, it is usually the attorneys who have mastered the art of civility. It might be who they are as a person, or maybe they've trained themselves, I'm not sure which, but it doesn't matter. They're extraordinarily effective. So there's just that personal side for your success as an attorney. But then, of course, there's the societal aspect. What are courts for? They are where we go to solve arguments without having sword fights on the street, right, or gunfights. That's where we want to take conflict. And we want to get down to the brass tacks of what is the argument about, and solve it in a way that obviously doesn't involve violence and hopefully not hyperbole. It works its way into our courtrooms. Obviously, we as judges and appellate judges see hyperbole all the time. I can promise you that that's not going to be persuading your audience. It might feel good when you write it, but you want the best argument, but you also want what's sort of best for the third branch of government. And I really, really believe at this moment in time, the third branch is really important because we do have these rules, but also institutional norms, which we want lawyers who set the table, along with the judges, to be reflecting back to society about what this can look like. We can make hard decisions. We can make controversial decisions, but we can do them in a way that is with civility and give integrity to our third branch.
Right. Well, Justice Welch just touched on this. Chief, why is civility important for the third branch of government? Because we're a little bit hamstrung in our ability to engage in the public debate like the other two branches of government, but yet we need to be respected as a separate but equal branch. And why is civility important for that, if it is?
Well, I think it just goes back to your original question. As the institution itself, the judicial branch, even if you go back to the Federalist Papers, 78, Alexander Hamilton really talked about judges using reason and judgment to make decisions, that we would not have control of the taxation purse or the sword, and we would need another branch to go forth and enforce our orders. I think when you get to the heart of that document and others, it's really going back to what the justice just said, is in order to resolve conflict, legal conflict, the court must be neutral. It must not be biased or prejudiced, impassioned with argument. To me, that all lends towards civility.
Well said. Do you feel like, because I'm old enough to remember when we didn't really have to talk about civility because it was just sort of there, and I feel like we've either progressed or recessed to a place where we have conversations like this. Now, maybe I was just, oblivious to incivility, but I felt like, I don't know, even when I first graduated from law school and was a law clerk, civility was I think a little bit more the norm, and for some reason I feel like it's lost us a little bit. I remember Judge Potter's advice about civility to me when I was his law clerk. He said, when someone says something to you that really makes you angry, you need to walk a mile in their shoes. And I thought for a minute, and he followed up with, because then when you respond, you'll be a mile away and you'll have their shoes. Okay, so, but that's a bit of a, I think that's, although that was intended to be funny because he was one of the funniest people I've ever known, it did talk to empathy a little bit, and I think sometimes a lot of what we talk about civility, some empathy goes a long way. Just be recognizing, and it actually works to your advantage also, because part of being a great chess player, right, is anticipating what the other side's move is going to be, and it's really hard to do that if you don't get inside their head a little bit and think about what they're thinking. Well, empathy allows you to do that a little bit. Both, I think it gives you a tactical advantage, but it also makes you, I think, more civil. I guess I would ask, to some extent, it's hard, and I think we get in trouble when we try to codify civility. Okay, because how do you codify conducting yourself in a civil? It's tough for me to do. Yeah, we can outlaw certain things, and you can't. I bet every judge who would think about it for a minute would say ad hominem attacks are the singularly most ineffective technique that any lawyer ever does, and that's just a fancy way of saying attacking the other person, not the argument. But I don't know, what does civility look like in the modern practice, or if you define it by, sometimes you define things by what's not civility. Do you guys have some examples you might want to talk about, things that when you see it, you say, yeah, that's the way we should be doing this, or conversely, don't be that person. Justice Welch?
Sure. So it's interesting. I'm I am now middle age, I guess they say. So I'm 55 years old. So I graduated from Ohio State in 1995 and worked in Louisville, Kentucky for a few years, then moved home to Grand Rapids, Michigan. And I had the privilege of working for sort of the legal legends, the ones who were very esteemed in the bar, and also the epitome of old school gentlemen, they were all men, civility. And they were a model of what, one of the lawyers was just frankly terrifying. Like, he was a very intimidating person, former JAG Corps, very tall. His courtroom presence was masterful. And as a young associate, he was a very intimidating presence. He was always lovely, polite, civil, so effective. He was an incredible mentor. So I grew up with that, and that was definitely the norm, at least in Grand Rapids, Michigan. But it's interesting because I heard the prior panel one of the professors talk about that in the 80s, they started tackling this because there was this concern about sort of, maybe aggressive litigation tactics and things sort of shifting then. So, I graduated in, 95, so you only know what you're in the middle of. And so I sort of wonder sometimes, and I don't know if it's like a little bit of us being like, oh, these darn kids, so I don't know that it's that different. The tools are different now, and that's probably what's maybe scary to those of us who are looking backwards and looking to the younger generation. Obviously, social media has changed everything. It's changed every aspect of our lives. And so somebody can make a rash decision and make a post really fast, which was noted on the prior panel, and you really regret that. Whereas in the past, we couldn't do that. So I can give an example. So many of my examples are actually from law practice, because I will say, as an appellate Supreme Court lawyer, I'll be honest, the litigants who come before us are really quite amazing. There's an occasional exception, but they are really quite professional, because by the time they get to us, we're seeing kind of the really best of our legal skills in front of us. But obviously, as a trial court attorney, I saw all kinds of things. And I worked for a big law firm, and then eventually I had a small practice and a solo practice. And when I was a solo, I shared space with other lawyers. And one of the best parts about sharing that space was checking each other's worst tendencies, because you would get upset about something. And so there was one time, one of my dear friends brought a letter into me. He was so angry. This case was just very hot, and the parties were really mad at each other. He brought this letter in, and he goes, I just need you to read this. And I literally read it, and I go, okay, so we're gonna put this in my drawer for the night, and then tomorrow we're gonna revisit this, because this is gonna land in front of a motion in front of a judge, and you're gonna look terrible. So he was like, you're right. So that's where, sometimes we're there for each other, right? Because we deal with really emotional issues. I don't think that's changed. I just think that the rapid way we can respond, just even email. When I graduated from law school, it was right on the cusp. Email was starting, but it wasn't the primary mode of communication. You sent a letter. You had your legal assistant draft the letter. It went through 3 rewrites. So there was time, even for overnight communication. Now it's a quick email you send, and you might say something you didn't mean, or maybe even unintentionally be sharp. So that's what I think has changed. I don't know if the personalities have changed. I think it's the tools we're using. And so I think that's what we have to figure out as a profession. Is that exacerbating things? Is it making things worse? how are we going to manage that? And that's obviously going to be on all of the folks out here, how you manage that in your careers moving forward.
I think I've seen a generational change. So when I was in law school, I clerked for Judge Crehan. And Judge Crehan came to the law having served in the Marine Corps during Vietnam, graduated schools in New York where he grew up, and then to the FBI, and then to private practice at a relatively prosperous small law firm in the city of Hamilton. And when I clerked for Judge Crehan, it was really that era of they knew everyone. There wasn't anyone in the Bar Association that didn't have a relationship, that didn't know the other lawyers, knew their children, their wives, their spouses, and there was a camaraderie there that is unparalleled. And I do think the tools of change have really eroded what I find in that camaraderie that they had, where they would argue against one another, but they would still have dinner together that night. They were not careless with their words towards each other. And I do think, as the Justice and the other panel said, that these tools that you have are very dangerous. And they can cause you to not only lose respect of just human dignity, because it's so easy to fire off these diatribe of hate. I also think that it really is impactful of who you are as a person, and to be more reflective of what does that say about you. So I do see that change in generation. Perhaps it is the tools, but I also think that with this technology, we are becoming a society that disassociates from one another. I think one of the struggles that bar associations have talked to me about is how do we get young lawyers to come to bar functions, to be part of that group. And I think that is a struggle of the technology. They don't want to have the conversations or go to those receptions, and that's where you develop those relationships as my predecessors did. So as a young lawyer, I went to all of those events, socialized, still a member of my local bar association, go back to events whenever I can. But that connectivity becomes an important thing. It's much easier to say something mean about someone or to someone when you don't know them and you're not facing them.
Yeah, I'd love to just piggyback on that.
Sure.
It's funny, I had breakfast this morning. One of my former clerks is now working with the Ohio Court of Appeals, and we had breakfast, and we were talking about it. I asked her, I was like, have you joined the young lawyer section? Have you, I'm like, this is really, if there's some wisdom we can impart, it is, I think all of us can speak to those bar association relationships. They're some of my best friends, and a lot of them were opposing counsel. So, but the relationships got built, outside the litigation, in the litigation, but outside of it too. So it's really, really important, and I know that's been a shift. I know every association, no matter if it's the bar or other professional groups, are struggling with figuring out how to get people back in the rooms. And I think it will course correct. I think a lot of people are gonna realize, gosh, if I wanna have a client book and I have to get to know people, and so I think it's probably gonna, each generation figures it out, but I know that's something the associations are trying to figure out. How do we meet people where they are, and what do they need, and how can we get them interacting with each other? I know Toledo, I heard lots of talk about Toledo holding itself out very proudly as a very congenial bar. I come from Grand Rapids, Michigan, exact same thing. We really, really do kind of all know each other, but Grand Rapids has grown as a city. It's harder to know everybody. The other phenomenon that's happened is you get more counsel coming in from the outside than you used to. In the past, that was less of a thing a long time ago. We've all been like, oh, New York's in the room, so it's just different. And when Detroit, I was at a bar event, and some of the Detroit lawyers were talking proudly about the Detroit bar, but then one of them has been in Grand Rapids recently and was like, oh, but Grand Rapids is even nicer. So, you know, each has their culture and are pretty proud of it, but it's like, yeah, maintaining that is important even as we grow. We have to figure that out because it is, as Justice Kennedy said, it's about the relationships.
So, exactly, and hitting on the Bar Association stuff, most of my legal career in private practice was representing a railroad. So I pro hoc viced into countless other places, and I didn't have red slippers, but I certainly clicked my heels together and said there's no place like home a few times when I was on the airplane coming home. And a big part of that is something as silly, which the students watching who plan to practice in Toledo, there's this thing called the Gridiron Show, which is a musical comedy thing. It sounds like a total waste of time. I am positive the way I got selected out of a panel of probably 75 or 85 probably more qualified candidates was because a bunch of the people on the screening committee I knew through the Gridiron Show. And it's hard to be, it's much easier to enjoy the practice of law when you have some interpersonal capital with the person on the other side, whether that's, you know, having sung a song or danced in a dance together or any number of things that happen. So if you take nothing else away from what I said today, get involved with the Bar Association generally and the Gridiron Show as you're starting out, and you will thank me because you will build this syndicate of people, opposing counsel, people that may practice in an area where you have something come up and you need to get a quick piece of advice about what do I do next. All right, so that's my what do you do better. My working hypothesis for today is the worst thing that has happened to the practice of law is email. Okay, email there's such little upside to it, and there's this massive downside. The delete button is your friend when you come up with that snappy retort to the email that made you really angry, like that letter that went in the drawer. The delete button is your friend because we feel the need, we get an email and it makes us really angry, and we put all of that emotion, we respond from an emotional place, and we escalate it, and we make it worse. And it's not just opposing counsel. I had a client who was at the aforementioned railroad, which will remain nameless, but their logo is a horse. One particular, who I love this inside counsel, but she had, if she was jammed up on something, she would write an email. And the one thing I learned quickly on is there was nothing I could say in an email that was going to make this better. And invariably, it would make it worse. I very quickly learned to pick up the phone. And we would have a conversation, and we would talk about the Phillies, and then we would talk about, her mother, and we would talk about 7 other things, and we'd get down, and she'd say, "Oh, Jim, I'm sorry about the email, but Roger came in, and there was a form missing, and can you just get me that when you can?" And it was a happy chat, as opposed to, I had a law partner who could never figure that out, and he would respond with an email, and it would invariably get spun up to where I'd have to intervene to settle them down and save the client relationship, and that's with your own client, okay? I hate email. Okay, you pick up the phone, you have a conversation. What does that do? Well, first of all, you are never going to say things to people. First of all, you cool off a little bit. You take that walk. You take the walk in the other person's shoes. Okay, but second of all, when you do talk to them, it's a conversation. Okay, and it's a conversation. And third of all, there's not going to be a written record of it that's going to become Exhibit A to the motion for sanctions, okay? So there's no downside in my world to picking up the phone as opposed to snapping off the email, okay? So that's my thing. I wanted to share one example of what I think is like the quintessential civility, professionalism, and this happened in my court not that long ago. There was a brand new U.S. attorney who had come over from the state court prosecutor's office as a gun guy. He was going to be a gun prosecutor. And one of his first cases was a drug and gun charge. And we had a preliminary hearing, which is just a probable cause hearing. And this defendant was charged with a pretty significant drug problem, drug conspiracy problem, but also felon in possession of a firearm. Well, at the preliminary hearing, the U.S. attorney put on all the evidence about the drug situation and the search warrant and what they found and everything, found this gun, and he got done, and the defender got up and said, we move to dismiss the gun charge because he didn't prove that the gun had traveled in interstate commerce, and indeed he hadn't. Okay. Now I know that Glocks aren't made in Ohio, so I knew he could have, but he didn't. Now I'm sitting up on the bench, and I know this there's two things about a preliminary hearing. First of all, if the charge is dismissed, they can literally, on their way back to their office, stop by the grand jury and get the case indicted, okay, first of all. And second of all, there was already a really significant drug charge there, so this guy wasn't going to get out. He wasn't going to be released. He just had one of his counts. So I dismiss. And the AUSA is very upset, very scared. He's moving to reopen the case so he can put in, his evidence about the Glock not being manufactured in Ohio. I said, no, you had your chance, you didn't, and I dismissed the gun charge. Now, literally, they indicted the case that afternoon because there's a grand jury all the time in Cleveland. Ours in Toledo doesn't sit that much. But the next morning, I couldn't help myself. I called this young prosecutor just to make sure he was okay. And I called him, and he answers the phone, and I can hear, little kids screaming and everything in the background. He's obviously at a CYO track meet, which if you've never been to a CYO track meet in Northwest Ohio, it's like a festival of frivolity, and it's just a fun time, and it's like a class reunion with everybody. Anyway, he's obviously at a CYO track meet, and I said, I won't say his name, but I said, how are you doing? And he started laughing. And I said, what's so funny? He said, well, I'm stunned that you're calling me to ask me how I'm doing, and you also need to know that the defender called me last night to make sure I was okay. So that's civility and professionalism, okay? And that's people who have some interpersonal, because those guys are going to have to be working with each other the rest of their careers, okay? And she was genuinely concerned and wanted to reassure him, as I intended to do. It wasn't that big a deal, but by God, I'll bet you every time for the rest of his hopefully very long career, he will not forget to prove that Glocks aren't made in Ohio, okay? So that's what it looks like in my world. I don't know. So as a judge, and you're both at the appellate level now, but Chief, you were at the trial court level, how does behavior in the courtroom, it's certainly different when there's a jury there, it's different when there's a judge there, it's different when there's an appellate panel there, and I've never actually argued in a Supreme Court, but I assume it's even more different there. What does civility look like at the various, because I have seen people show up in the Court of Appeals and pretend like there's still a jury there, and I think that's pretty wildly inappropriate, but I don't know.
So I think that as I look back on my career, it does look different at every stage, even as a police officer. So you're just really a witness in the courtroom, and you strive for professionalism, answering the questions directly, not developing a tone or not really shading answers or being evasive. But then when you stepped into the world at the trial courts, and I was 14 years in the domestic relations world. So it's a tough docket because you are seeing really good people at probably their lowest time in life. But you also have, as litigators, you have that aggressiveness, or you wouldn't be in litigation. There's something about litigators and that drive that makes them good advocates. But I also think there's a balance. I think you have to recognize who you are as a person and the things that cause you to lose control of your emotion. I can't make you do anything. I can't make you feel anything. Those are personal choices. If you get angry, you own that. And you would have lawyers that you knew were oil and water. And you saw them on the docket, and you knew it was going to be a difficult day. And it really started having conversations with them separately, because their bad behavior and the way that they would interact with one another was really just compelling litigants to believe that it's appropriate to act in such a discourteous manner towards another person in a courtroom. So to me, I worked very hard recognizing when I recognized that I had difficult personalities coming together, I worked very hard at trying to maintain civility by having the conversation with them before they started in that. But there's also great opportunities to learn how to problem solve outside of the box. So 2 of those lawyers were together. It was a very high-profile divorce, a lot of money at stake, and it all dissolved down. They had settled a $5 million case, but the parties were going to argue over a Rubbermaid trash can. It was brand new. And finally, the lawyer, who tended to be somewhat hot-tempered, he really just took the step back to say, I can make this bad situation worse because I can then use my anger in response, or I can be creative. He stood up from the conference table, he opened his wallet, he asked how much the new Rubbermaid trash can was, and he laid $20 on the table and said, who would like a newer Rubbermaid trash can? And with that, that's exactly what happened. The parties started laughing. He took his $20 back. They realized that they were being silly, arguing over a trash can. But in those moments when you have someone who you know you are already emotional about, you do not like them, it's okay not to like someone, but it's how you respond to them, because you own that. And do you really want people to live rent-free in your mind? Do you really want to expend all of that energy? Because it takes a lot of energy to be that angry and visceral, as opposed to just being kind and just ignoring it. At the appellate stage, we have the marshals who are there during oral arguments. They're not going to let anybody get towards the bench. The only time I thought I'd see a marshal leave their post was when a lawyer was pounding on the podium for emphasis. Not something to do when you're at the Supreme Court of Ohio. So it's completely different from litigation to being a witness, to being a litigator, to being in the trial court.
Yeah, and I want to just add too, sort of from the judge's perspective, as a litigant in trial court. I was not a trial court judge, but I was a litigant. The best judges are human. They might have really hard things going on at home. They might be exhausted. They're going to have a bad day once in a while. Even the best judges, I've seen it happen where we walk out, we're like, oh, what is going on? And Judge so-and-so, he's usually so kind, and he's in a bad mood. I have watched judges lose their cool and yell at litigants. I have also watched those judges or heard about those judges afterwards calling the litigants to apologize. So that is huge. Or calling them in later. State court's very informal. They do that, as you know, like back in the day, and apologizing for losing their cool and admitting I was having a bad day. And I know you were just advocating for your client and you were trying to build a record, because it's going to be really hard for litigants. They're sort of annoying to the judge, but at the same time, they are trying to build their record. So I think that goes a huge long way for the bench when a judge owns that. I think that's really important. And as far as appellate advocacy, like I said, and the Chief Justice has mentioned, we don't see the same sort of shenanigans you see at the trial court level, which I firmly believe is in the trial court's purview to control their courtroom, and many do it masterfully. Probably the biggest thing we see, and I'm sure you do too, is more like briefing and what they do in their briefs. I mean, well-done briefs don't cast aspersions that make it personal, but occasionally they do. A lot can happen in footnotes, and I get a bench memo from my clerks, and they will often say, this brief is terrible, all it is personal attacks on the other party. Like, you can read it if you want to, but it literally is not helpful. And then my clerk is parsing out the law so that we can figure out what is the legal argument and do the job for them. So luckily that doesn't happen that much, but I'm stunned at how, it does. They do come through. And then also we will see briefs too that maybe attack the court itself and its decisions. Again, legally fine, tear apart the arguments, no problem. But when it starts to sound sort of personal, that's probably not the most effective advocacy.
Yeah, does anyone disagree that the worst thing you could possibly do is an ad hominem attack on opposing counsel?
Yeah.
Much less the judge, I guess.
It's just, fascinating.
I've never met a judge who didn't just say that. I mean, it's flat out. So what about if someone is, I'll say, well, first of all, I hate the word zealous advocacy. I wish that word had never come in, because what's a prerequisite to being zealous? Well, you have to be a zealot, and I don't want to be a zealot, right? So I think that there are ways to, when we start using aggressive and fight, I think that becomes a cover for doing some things that we wouldn't do, and we shouldn't do, because the prior panel made the Professor Grenardo made an analogy to football styles of play of football linebackers. I mean, think about boxing. Okay, in a boxing match, the boxers come out, they shake each other's hands, the bell rings, they punch each other in the face for an entire round. The bell rings, they stop, they go back to their corners, and they do that 8 or 10 or 12 times until either one of them knocks the other one unconscious or the fight is over. But even during the fight, there are rules about where you can punch and where you can't punch, and that's about as aggressive as you can possibly be, but that's not a free-for-all, and they're not out. When the bell rings, they stop, and they shake hands again. So I think there are ways to be effective, but I think a lot of people substitute bluster and attack for tact, because a tactful response or a tactful proposition made in a motion or a tactful response is way more effective than a bluster of just spewing forth any number of things that might contain an occasional pearl of wisdom or something, but the rest of it just dumbs that down. And if the other side's brief is the dumbest thing that's ever been put pen to paper, and to paraphrase the movie, we're all now just a little dumber for having read it, I'll figure that out. You don't have to tell me. Tell me why you're right. Tell me if they went off the beam a little bit, but don't attack them. Okay. Do judges have an obligation to intervene when conduct is incivil? And I didn't know about this. I used to have a P number, but I don't recall that that's if you're admitted in Michigan.
Yeah.
Okay, if you're admitted, but you guys don't have inactive status. I'm inactive with you, Chief,
I know,
but for Michigan doesn't have inactive, so I would have had to keep paying dues. So I resigned. I figured although I think it happened to me now is get impeached, and the odds of 60 senators getting together on anything, much less removing me from office, is fairly remote. So I relinquished my P number. But you have a civility code. Sometimes I think codes are worse because they define what is illegal, but this isn't illegal, so it's okay, right? So what is the obligation of judges and courts to intervene either formally or informally through discipline or through that phone call or a call to disciplinary counsel? How does that work in terms of when you see uncivil, incivil, discivil, I don't know, but people behaving badly? What do you do?
Yeah, it's such a good question, because it is very rare that we refer something to our AGC, the Attorney Grievance Commission. Occasionally there will be something that is so egregious that, you know, we're supposed to be a self-policing profession, right? That we feel like we need to, I mean, certainly opposing counsel could have done it, another lawyer could do it, but there are times that we see a case and there's something that's extremely egregious. It's not frequent. So it's not like we're running around policing civility. In fact, I can't think of anything that's really about civility recently. Obviously, the code, I mean, a lot of it's, you know, aspirational. I pulled up my phone because I just wanted to, like, there are things that are everything we're talking about. We do not attack, disparage people involved in the justice system or employ gratuitously hostile or demeaning words in our written and oral legal communications and pleadings. It goes on and on. There's 12 points. It was put together by a state bar committee, sent to the Supreme Court with a recommendation to adopt this sort of code of civility, and it happened in, I think, 2023, so pretty recent. I think it was responding to a lot of these concerns, and I guess just sort of reminding people this is how we should behave, and we did adopt those. You know, we do have an attorney grievance commission. I'll be honest, most of the stuff is related to trust accounts and, you know, like all the normal lawyer things, that refunds that didn't happen, whatever, you know.
Dating your client.
Yeah, I mean, yes. It has, I haven't, admittedly, like sitting where I'm sitting, I haven't seen a lot that has to do with civility. But it also means it just didn't get to me, right? So the process is, you know, somebody files, you know, a claim, and then the Attorney Grievance Commission investigates, and then maybe they, you know, somebody makes a decision to, like, recommend a reprimand letter or something, and that may have happened. Probably that's not going to come to us. So it could be that it's happening more than I realize, and I'm just not, you know, I don't have that information, but it is true that most of the civility, to your point, it's not the codes and rules, and it's mostly about professional expectations as a profession.
So I think that obviously in the trial court, I had a responsibility to intercede, to ensure that it did not devolve down into fisticuffs, which it could have. Mm-hmm. I did not grieve any of those individuals. I think that it takes care of itself, and I say that in that if you're filing motions that are frivolous, Rule 11 sanctions are going to apply to you, and you're going to be responsible for the opposing counsel's attorney fees and court costs. So some of that kind of bad behavior takes care of itself. I do think that all of us should be caretakers of one another. I always say that when somebody is engaging in road rage, I like to say that they're just rushing to the hospital because they have a loved one who's dying. I don't know what's happening to lawyers when they have that kind of bad behavior. Maybe they are having a difficult day. Maybe they lost a child or they're facing cancer. So to walk a mile in someone's shoes, I think, is an appropriate stance to take, because you don't have to act like they're acting, and you hold yourself to, I think, a higher standard and more professionalism. Like Michigan, we publish professional ideals. So I do a lot of CLE and for bar associations or lawyers groups on this whole conversation about professionalism, reflecting on the ideals. A lot of it comes down to the do's and don'ts. And I actually think when you read this, I always think of my grandmother, because these are just really simple rules to live by, to just be a kind person. So we would have that as well.
I literally, in a discovery dispute one time, quoted at length from everything I needed to learn in life I learned in kindergarten. Okay, and so it's kind of in there. You know, don't hit people. Wash your hands after you go to the bathroom. I put it all in the footnote for them. I figured some of it would help. So I think it's something of an understatement to point out that we live in politically charged and polarized time, and the last panel reflected on that a little bit as well. I believe to my core, it's important for courts to not be perceived as political. So I bristle when I read an article about a federal judge doing something, or even the Supreme Court, the breakdown, that they can't help themselves but denominating who was appointed by which president, and to me that inherently causes the public to just view the courts as political. And that's in the federal courts. In the state courts, at least around here, Michigan, everyone is popularly elected, right? Ohio, everyone is popularly elected. How do we build a separation, a fire line between the politics of electing judges and an institution, a third branch of government, which should be inherently apolitical? And Justice Welch, I'll ask you first.
So, and it gets even worse in Michigan because of how we select our justices. So the rest of the judiciary goes out and gets signatures, gets on the ballot, 100% nonpartisan. The Supreme Court, it's part of our Constitution, the political parties nominate the candidates who then run nonpartisan. So I work very hard I'm not in partisan rooms at all at this stage in my life. Obviously that's important for the job, but then the year I have to run, I have to be in partisan rooms to get the nomination. So it is, that leads to, that makes it especially challenging. Now, what I can tell you is we have 8-year terms. That's by design. We have the longest terms of anybody else in the state, obviously to insulate us from the political process. I just don't go in political rooms, but additionally, I speak often, and I wish I could tell everyone if they could pay attention more to how many opinions are not divisive. Like, sure, there's the ones that get a lot of ink and are, big deal, big maybe hot button issues of the day, but a lot of opinions are, I'm on the so-called liberal bloc, and yet there are plenty of opinions where I am with one of my, conservative colleagues, and I wish that people would highlight that more. That shows I'm probably doing my job correctly. There might be some people who aren't happy with me, but that means I'm doing my job correctly, right? So I spend a lot of time talking about that, looking at, and again, highly professional disagreements. I think that's super important too. Our writing should never politicize the issue, and that's disappointing if and when that happens. And doing my best to diffuse if I feel like a colleague has gone there. And we have a robust editing process. Appellate courts are a group project. We have 7 justices. You need 4 votes to get a decision across the finish line. And if you're in the majority, trying your best to make sure it's reflecting what you would say and not joining if it's, venomous, or getting them to tone it down, or writing separately because you're like, I can't join that. That's not how I would say it. So that's, the tools we have. It's hard. How do we convey to the public our true effort to be that we are nonpartisan? How do we convey that? And it's hard because we live in an age where the way the coverage is conveying it differently. So it is challenging. I don't have a great answer other than we just keep trying and coming to forums, and I show up in any room I'm invited, and I'm happy to talk about how much we work well together. I have a court that's great. We get along really, really well. And I'm very proud of that, again, across ideologies.
Chief?
I think it really is 3 separate conversations. As someone who has been a candidate at not only running for the trial court, but running for the Supreme Court, as a candidate, I make a choice. And I make a choice whether or not to get involved in the name-calling vitriol that goes on in some campaigns, and I just refuse to do it. In the last campaign, so Justice Bruner and I ran against one another for the chief's seat. We were on a panel last week together at Bowling Green, and we really made a decision. We were going to be colleagues, period, at the end of this. You could be a good colleague, or you could end up really causing a divide in your relationship. And I just chose that I was not going to do that. I was not going to create this animosity between her and I, because we have a relationship beyond this race. There were those on her team that did not really aspire to that and really did break down at times. And not only is it hurtful, but you also then have to recognize that it is politics, and it really says more about them than it ever would be me. So they took my picture at a rally where I was waving. And of course, the first thing that comes out that night on X and Facebook is, I'm a Nazi, I'm Hitler, because I was giving the Hitler salute. Now, they knew very well what I was doing in that auditorium, and it ran a cycle for a couple months of them saying I was a Nazi and saying I'm Hitler. And this is where you really have to have thick skin, and you have to choose the high road. Because I could have responded, I could have gone after Justice Bruner for what her team did. I just didn't. It was not worth any of my energy to focus on pure idiocy. So you really do have to hold yourself in those moments. I think as it comes to the politics of running, you will always have those who do those things. That is just part of it. You just have to rise above it. So I've seen that at all levels of campaigning. I think the hardest part to me is when they put R's and D's behind our names for running for the appellate courts in the state of Ohio. I was not in favor of it because I do not make decisions based on political ideology. Are there some who say it? Absolutely. It's the first thing the media says when a decision comes out of my court and they disagree with the decision. It's pure politics. And what I would say to everyone, read the decision. Sit down, take 10 minutes, read the decision. Because what I think you find in the decision is exactly what we should be discussing. What was the text of the provision, whether it was a constitutional provision or a statutory provision? Did the General Assembly give us definitions for what those words mean? And to really work through the language to understand we're making a decision based on the text, not politics. I found in the very first case that I wrote as a majority author, State versus Smith, in 2013, that I never read the newspaper after that, and I certainly didn't read online comments after that, because the comments, they were just so ridiculous because it had nothing to do with the case. Obviously, they never read the decision. But in our role, mine is to only say what the law says, not what it should be. After State versus Smith was published, it is up to the voices across Ohio, if they don't like how that statute's interpreted, to go back to the General Assembly and have them take out the eraser and erase those two sentences and write something else. Not my job. I didn't run for the General Assembly. I never want to serve in the General Assembly. I like exactly what I'm doing. I believe this is what I was put on this earth to do. But you have to be those who are informed. You have to be the knowing ones in the room. And you have to then say, in defense of the judiciary, did you read the decision? You can't criticize it until you do.
And I would note the media often does not summarize it correctly. Like you'll see a byline and you're like, huh, that's what it says?
I love the titles. I love the titles because it's not what was said.
So I think I share the chief's disdain for partisan monikers after names on the ballot, and I got to say I was dumbfounded when not that long ago the local newspaper did an editorial about that. And I thought, well, here's going to be the voice of reason, and they were not lamenting the partisan designations on appellate level races, but advocating for them to come down to the local trial level, because that would make the citizens more informed about the ideology of the person they were voting for. I'm like, wow, that is really disappointing to me on so many levels, that journalists would think that an R or a D after someone's name. And okay, full disclosure, I happen to be married to someone who was nominated by a Republican governor and had to run for to keep the seat in a predominantly Democratic county, and it probably would have been tougher for her if there had been an R after her name on the ballot. I was glad there wasn't, but you can't look at whether I don't know any judicial officers that I would say, knowing, particularly at the trial court, because my best friend and colleague is Jeff Helmick, who's the other active district judge in Toledo. If you would hold, back in the day of punching out Chads, on the ballot, if you would hold his ballot and mine up to the light, you would not see a lot of light come through, okay? But we agree on 99% of judgy stuff, because it's calling balls and strikes, folks. It's not, at the trial level anyway, I don't have the luxury of deciding great societal issues of what the law should be. I got to do my damnedest to figure out what the law is, and he does the same thing. And it's really refreshing how much we agree on things, and it does nothing to move the ball forward to know who appointed him and who appointed me. I'll just tell you, okay? Maybe some practical advice, because part of civility, I think, is how we conduct ourselves in the courtroom, but sometimes outside the courtroom. And there are cases that have the need, maybe not the need, and I'd like to hear what both of you think about, a lawyer who's involved in a very high-profile, emotionally charged case. Pick out whatever it is, either a very high-profile criminal defense case, or a very high-profile, maybe an election case, or a civil rights case. What advice would you give to lawyers to do what they need to do, and if they perceive that they need to do something outside the courtroom, to still maintain civility because civility isn't just when you walk in the courtroom. Civility is all day, every day. All right, Justice Welch?
Yeah. I think we certainly know there's certain attorneys who are in front of TV cameras a lot, and that's just part of their practice and the types of cases they take. Some choose that they don't do that, they don't have to, but some do, and some of them are high profile, and that's probably appropriate. Again, though, it's using those same guardrails. What am I talking about? I'm talking about the justice system, I'm talking about trying to get justice for my client, but also not, again, throwing aspersions, making personal attacks, and some do cross that line, but a lot don't. A lot do it very effectively. And I get it. We live in a world of sound bites and social media posts, and a thriving law practice probably adopts a lot of these principles to generate business, and that's just how we do business now. So, but I think some do it well, and they're just adopting the same principles that we're talking about here.
I think it really goes back to something my grandmother would say, which is never lose sight of yourself. You answer only to you, and you have to look at yourself in the mirror. I agree with the justice that as a trial court judge, there are days that you get to the end of that docket and you're not in your best moment. Had one of those, called the lawyers. Actually, they were both in the courthouse the next day and apologized. We're all human. Never lose sight of yourself. And I think if you're representing an individual who wants you to really go after counsel, screaming, those types of things, it's really your opportunity to say no. You are responsible for your own conduct, and to help your client understand what the practice of law truly is and what you can do as an advocate. But once you become the focus of that litigation, I think your client's interests leave. And what I mean is, if you become the focus point of that emotional roller coaster, how well are you advocating on behalf of your client? You can be passionate about things. I clearly am a passionate person about certain topics. But at the same point in time, my personal emotion, the case isn't about me. The case is about my client. So much in the domestic relations court was, just easy targets for a lack of civility. But then you really saw people who really took that mantle and really shone through all of that in order to elevate their client's position. So I do think it's a personal choice that you're going to make every single day. Who are you? What do you want to be known for? What is the reputation you want to leave behind? And you own it.
Is it ever okay for a judge, either at the trial level or the appellate level or the Supreme Court, to, I don't know, we heard about tactical incivility. Is it ever okay to dress somebody down in an opinion or an order?
Well, certainly, if you read some of our cases, we have dressed down the majority or the dissent if you're in the majority. I have seen some that really was a bridge too far. In talking with colleagues, they then rolled that back. So I do think there is an opportunity to do that. I do think we should be careful with what we write because, again, speaking through our decisions, that is forevermore. So I do think you should be careful about what you say.
What about toward a litigant,
No.
an attorney? Right.
No. I have a drawer, and in it is a file folder of my most favorite motions that were ever filed when I was in the trial court. And one was a lawyer, and I won't say his name, who basically literally called me an idiot, that if I actually knew anything about the law, that I would have done X, Y, and Z, and I was a big blanket idiot because I made a decision the other way. And it was a motion for reconsideration. And
Very persuasive.
I cling to those because it's that reminder of, don't ever go there.
Yeah.
So as a new lawyer, it was the fax machine. And I got 2 faxes from more senior lawyers, and they were telling me that they were going to take my license. Now, remember, I had had my license, the ink wasn't even dry on it, and they were gonna make sure that the Supreme Court of Ohio took my license. And of course, as a young lawyer, you fret, you worry. So I suffer Catholic guilt. So I sat in the office and said, oh my gosh, what have I done? What have I done? What have I done? And then I waited for the more senior lawyer to come back to the little shop where I was renting space. And he gave me relief in that he says, well, this is what you do. You go fax back to them. And I said, okay, I'm not going to do that. I am not going to be them. But to find somebody that you can have the conversation with and strategize for those tough people. So when I know I had to deal with those tough lawyers, I brace myself for the day. You have to do it too.
I will say a responsive fax is never an 8.5 by 11 sheet of paper with a Sharpie outline of your outstretched middle finger, okay? That's never okay. Justice Welch?
Yeah, I was thinking about the litigants. So by the time stuff gets to us, we get, like ineffective assistance or things that like the lawyer really has maybe messed something up. And it's interesting because I'll go back and forth. My clerks are lovely, but most of them have not practiced law. Some of them have. And once you've been in the trenches and been a lawyer, you know how hard it is. It is really.
They don't have the empathy for what the lawyer is
Yes,
going
and
through.
I tend to find that's one of the top things I often am pushing back, is like, oh yeah, that's not how it works in real life. Like, this is like a defender who had, how many other cases and was running around to courtrooms and, maybe missed. So I find sometimes that maybe there's a desire to call a lawyer out and be really vocal. I mean, we're still finding maybe ineffective assistance, but there's a way to do it without being like, what a terrible lawyer, because sometimes they actually aren't terrible lawyers. There was just a big mistake in the file. So that's one thing I just find. I find like tempering that by the time we get to that final draft, making sure it's kind, figuring out how to point something out without being like, you're a terrible lawyer. Obviously, if there's been egregious misconduct, more our trial court lawyers see that. By the time we get to the Supreme Court, other than a brief that's ineffective, which I'm just going to ignore it, we're not responding to the ineffective brief. I'm not dropping a footnote to point out like how absurd the brief is. I could. I don't. I will tell you, our court in the late 90s, early 2000s, it got very contentious among even the majority at the time. It made like the New York Times. One of the justices wrote a book. It wasn't great, and it was really hard for the bar. Because they were watching this and the footnote battles. So I'm still like, when I'm doing research for a case and I find an old opinion and then I'll read in the opinion, maybe whatever the holding, and I'm just trying to and then I see a footnote responding between the dissent and the majority, and you're like, oh, like just ideally, not ideal in my opinion. I would, if there's that temptation, maybe it's in an early draft, but boy, it's got to be stricken, is my view. It's not helpful. It's not moving the law. I don't know why. It just doesn't move anything.
Well, we are known for the pushing over a desk and fisticuffs between two justices.
Yes, you are.
I mean, it happens. It happens. I'm not, figuring out how do you move past it.
Indeed. So I think as a judge, we have to be really careful. There was talk about judges being bullies, and I think you have to be really careful about that. And I think there are some people who become judges who shouldn't, because they do have a tendency to become bullies, and that's sort of the quintessential bully. They can do something and there's really no one, the lawyers can't punch back, right? A judge can do something. And I pay particular attention to that when I have a jury sitting there in the box, and if a lawyer's doing something that they really shouldn't be doing, I really try to moderate my talk in front of to the whole court. I will call them up to the sidebar and I'll say, if you do that again, the next time I'm not going to bring you up to the sidebar to have this conversation. I'm going to have this conversation in open court, and the jury is going to hear it. So, and usually that modulates their behavior, because that's kind of the death sentence. If the jury hears you as a lawyer get dressed down by the judge, you guys, some of you are practitioners, some of you are law students. The one person in the room that the jury trusts is the judge, and if they see the judge get angry at one of the lawyers, that's really bad. So I have to pay particular attention to not do that. But I'm telling you, if you're, don't be that person who somehow gets, because the jury will notice it, and I try my hardest not to do that, and I don't think I'm knocking on wood, I don't think I've ever done it, but aside from not being bullies, justices, what can judges do to sort of advance the ball here on professionalism? Is that mentoring? Is that being involved in the Ends of Court program? I mean, what coming and talking at law schools? What can we all do to make the world a better place? Yeah. Okay.
Well, I think civility belongs to judges and justices in the first instance. It is about respect for ideas, for people, but also the institution. And I look at judges as being the caretaker of our profession first and foremost. So we spend a lot of time really talking about civility. The deans raised the issue of civility last year in one of our quarterly meetings. We did a civility symposium last year We're having our second this year. And we're really having some national speakers come in. Could not get the one gentleman who really is a law professor, and his symposium writes briefs that go before the U.S. Supreme Court, and how they were personally attacked for that brief, but no one had read the brief. So I really feel that judges in this space are the leaders, and they have to be. They have to be the person that every day in the courtroom, even on the long, tough days, they are a model of respect of all things, and that they lead by that example.
You know, the worst place you can be is on the phone call when the lawyer has to call up and say, my son's in the hospital, he's having surgery tomorrow, we had a deposition scheduled, and the other side wouldn't adjourn the deposition. You don't want to be that person, okay? And I've had that, and I'm thinking, really? This had to be a phone call? So don't be that person. Justice Welch?
I 100% agree. I find those stories shocking, yeah. So I think, yes, being out, doing what we're doing right now, this is an example. Ideally, getting into rooms that aren't just law students and lawyers. I try very, very hard to get into, your Rotaries and different groups that care about maybe, our system of justice, but maybe just want to learn more. I do think I know our court is working on just things like Pathway to the Bench and different things that are open to the public, and having forums and all the things to outreach into the communities. I want to say, as much as I love, love, love my job, and obviously take it very seriously, I think our trial court judges are really more important than I am as far as our community and reaching people. They are out in the community. We can have a debate about whether elected judges or appointed judges are better. We can have that debate. The one upside to elected judges is they are usually quite embedded in their communities. There's a reason they got asked to step forward. They are out. Our trial court judges are amazing. They are community leaders. They're engaged in all kinds of things. We are too, but they are hyper local. And they are quite, if you actually one-on-one, were to do polling, they are quite trusted. So even though we have this sort of institutional distrust happening, a lot of the polling shows that, the local courts are very trusted, and we want to keep that, right? And a lot of that is showing up, being present, and I know, our judges are amazing at that, and I think that's really, really key.
Chief, I'll start with you. What makes you optimistic about the future in terms of civility, and why? Because there's a lot of lawyer burnout, and I think incivility is one of the reasons for that, all the pressures of being lawyers. I think there's something to be said for the civility of practice, and I talked about the interpersonal capital, makes you not hate your job, okay? But Chief, what makes you optimistic that things are going to get better?
More public forums where people are actually engaging in the conversation, and it's not the emotion. So when you have these panel discussions in all types of forums with people with differing views or opinions, and you can see and then model that professionalism and the rate at which we're seeing those panels, I feel good about the future.
It's good to hear, Justice.
I can't really add more to that. You all are here. You are the future. You will take all of our amazing wisdom and apply it. So no, I really do. I think it's like there's always these generational stereotypes and whatever, but I actually, I know a lot, you aren't all Gen Z, some of you are beyond that, but a lot of you are, which is the same age as my kids. There's frankly, a kindness, even though social has made things so polarized. I think a lot of Gen Z is quite caring. I know it's maybe looks different than when I was the same age, but I'm very, very bullish on Gen Z. I think you're going to figure it out. So, you will find your way, because nobody wants to practice. It is one of the joys of practice is some of my best friends were opposing counsel. Fast forward all these years, I'm in this position because many of those people, they were some of the people who encouraged me to run. You want that joy of having the friendship of the bar and this amazing community we have.
I couldn't agree more with some of that. So I'm going to paint a little picture. Both of you individually, we're walking out after our session here today, and a very well dressed for a Friday young law student gets in the elevator with you, the doors close, and you got about 30 seconds to hit them with one piece of advice that you want them to take away to be successful, to have a successful practice. What one piece of advice do you give them on the elevator ride up to the 3rd floor? And I'll start with you, Justice Welch.
Don't burn bridges, because the person you're maybe mad at today could have a big stake in your future. So, and might actually end up being a really good friend. So I think trying, and again, that really has to do with civility even in your worst moment. So remember that early in your career, you have a long road ahead. A lot of people, well, I think I'm cutting in and out a little. A lot of people will be involved in your career trajectory, and you just don't know where it's going to go. I've told people many times, you be open to, I did not think I'd be sitting in this particular spot, and because of a lot of people behind me, I'm sitting in this spot, and a lot of them were on the other side of the V, so.
I think 3 things: be kind, never lose sight of yourself, and remember, whatever is happening with that other person, maybe they just need a little grace.
We actually talked about that last point at one of our last ends of court meetings, to the point where maybe you have an obligation as an adversarial counsel or a fellow lawyer in a firm. If somebody's normally a certain way and they're not that way, maybe they're advancing age and they've got something coming on, but at some point it probably rises to the level where you should either maybe reach out to someone else in their firm and say, I'm seeing some behaviors here that I never would have seen from this person in the past. Is there something going on? Is there something we can help? We have, there's a bar council here at the Toledo Bar Association, Peggy Madma. There are just, at some point it rises to the level where you probably have at least a moral obligation and perhaps a professional obligation to help figure out what's going on there. So, and my piece of wisdom to young people is, life is about is about networking, okay? And every person you meet, you just never know when that person is gonna at some point be in a position to change your life. Maybe they're in a position to refer work to you as a lawyer. Maybe they're in a position to recommend you for another position. When you're looking, you just never know, because even with law clerk applications, I get hundreds of applications for one law clerk position every year, and invariably it's some network opportunity either through this law school or through one of the Toledo's a small town, the high school they went to. There's invariably something that jumps off the page, or somebody makes a call and says, you need to talk to this person. So please don't underestimate the power of networking. And if someone, when you're introduced to them, said, I'd love to talk with you about that sometime, and they give you their card, call them. For every 100 people I say that to, probably 2 or 3 actually do it. And it could change your life, folks. So that's my advice is never underestimate the value of networking. And that goes along with, you can't burn bridges and networking, because that's sort of antithetical, right? So anyway, reading my coffee cup and making me be less me, I think it would be an excellent opportunity for us to transition into, we've got 2 very distinguished jurists here with us today. I would love to offer them up and for any questions that you all might have about, you don't get a lot of chances to ask Supreme Court justices questions. So when I had lunch with Justice Kagan, I asked her what lunch was like at the Supreme Court. So I was just, they all have lunch together after arguments.
Yeah, we do that too.
Yeah.
Hi, thank you for being here. I'm curious what your thoughts are on how the pandemic has changed a lot of the work we do, namely the Zoom conference and do you think there needs to be more in-person connection? Because I know, doing these remote meetings is great when we're busy, it's convenient, but I'm wondering if, trying to build those connections with each other as lawyers, even if it's something like a case status meeting, do we need to make more of an effort to meet in person?
So I'll say yes, as the trial court judge here. We got pretty sloppy during COVID about Zoom conferences, and yeah, that saves clients money and everything, but I will tell you, as a practitioner, there's a lot of times where more gets done before the meeting or after the meeting than during the meeting, and you lose that with phone. And I'm going to make a conscious effort. That's one of my New Year's resolutions. We have a brand new, beautiful courthouse, which you're all welcome to come down and see downtown Toledo. But I'm going to be doing more, particularly with local counsel anyway, coming. Now, I'm not necessarily going to make somebody get on an airplane from Los Angeles, fly to town for a 15-minute scheduling conference, okay? But I'm a believer in the in-person, just for the reasons you said. Justice Welch?
Yeah, so we are a hybrid environment. So my whole team is with me in Lansing on Wednesdays. Everybody comes in. The beauty of that is they can live anywhere in the state of Michigan they want. I don't care where they live. They just have to be in on Wednesdays. I believe, and that actually was before the pandemic because it's appellate work. It's a lot of reading and writing, so a lot of the justices operated that way even before the pandemic. Obviously, trial court judges, totally different thing, and I understand it's totally different. I believe, I was just talking this morning about this with my former clerk. The meetings, Zoom works great if you actually have relationships. I have found I chair a lot of commissions and task forces and committees, and I serve on all kinds of things, and a lot of them are on Zoom because we're able to get representation from the Upper Peninsula, which is 9 hours away. And that's important.
The Yoopers.
Yeah, the Yoopers. So we can now have lots of stakeholder buy-in and not have everybody drive to Lansing once a month, which would probably be unrealistic, and we probably wouldn't get participation from those places. However, the groups I'm in, we have at least quarterly in person. And I will tell you, when we do that quarterly in person, we invite them all to the Hall of Justice, and we have a big conference room, and we break up into work groups and all the things. We do get more done. The ideas are better, the energy of humans around you. So I think it works well. We've got these great ideas, and now for the next couple months we'll be on Zoom because we're implementing, right? I have found if it's a smaller Zoom, very effective. I'm driving back this afternoon. I've got an executive committee Zoom. That's going to work great. There's 5 of us. The bigger it gets, the more, sorry, I got my phone dropping. The bigger it gets, the more detached you get. You get the people multitasking. They're multitasking, So it can be done well, but it has to be done right. And I do believe that there has to be a hybrid. I think that works well, but it depends on the environment. For our environment, that works.
I'm an absolutely yes.
Okay. So there. Anybody else?
You need someone to ask a question, so I'll ask.
Not really. Nobody ever complained that the seminar got over 5 minutes early. I'm just.
Yeah, I'll piggyback on the last question about in-person interactions with counsel and the court. And so I know from my experience with the pandemic and reading some of the publications that came out of the Supreme Court, that the Supreme Court can't really, to my understanding, dictate what the common pleas courts around the state do in the manner in which they conduct their courtrooms. In light of the fact that I think there is a need from a civility standpoint that lawyers and judges need to get together. I'm a firm believer in the concept of networking. I think we're all of the same general time frame in terms of birth. That being said, what can the court do to encourage the trial courts to get back to where they were 10 years ago when pretrials were primarily conducted in person? Because that's where you learn not only about opposing counsel, but you learn about the judges. And that's important from a litigation standpoint because it is a human business, correct? So what can be done?
So you are correct. We are not a unified court system, so there is not a central figure that can mandate what they do. The 1968 Modern Courts Amendment gave the Supreme Court of Ohio rule-making powers, and really that was really about trying to eradicate overage cases. We have more rules in place regarding the role of a presiding judge and an administrative judge, but there is no rule that says you must be in the courthouse on X day and welcome lawyers in. I will say that the General Assembly enacted a statute when they created municipal court judgeships, and they are required to be in the courthouse every day except for 30 days of reasonable vacation, but they're the only court. All of that being said, if I were on the trial court, I would be in person every day. I accomplish more seeing the lawyers getting cases settled and moving my docket like that. I don't know how you actually move a docket if all you're doing is zooming in and having conversations, or you're turning that over to your staff and you, the judge, are not doing that. All I can do is do the encouraging. Obviously, I'm in phase 3 of my overage case reduction conversation with judges across the state. I feel as if bringing together judges and lawyers who did the survey and then finding solutions, part of that is coming together.
And I will speak to Michigan. We actually we can modify court rules. And we actually moved towards Zoom is allowed. Judges have a lot of discretion. And chief judges have a lot of discretion on, how their courtroom is run or courthouse is run. But we did say, for particularly civil matters, some of that, a lot of judges are actually doing a great job at it. The bar loves it and the parties like it. So I recognize there are pros and cons, and there's a time to pull the people in the courtroom, absolutely. But we give our judges a lot of discretion on that. I think this is the world we're in. I think the rest of the world has moved to this direction. So I think the bar will figure it out. It'll settle in. It got hard because Zoom, COVID was so one way. I think the answer is probably somewhere in the middle. And I think this is where bar associations are trying to figure out, they've got this sort of trying to figure out how to get engagement. And now engagement's even more important because people aren't necessarily hanging out in the court halls chit-chatting, where we know a lot of us learned that way. So I don't want to minimize that. It's this tension with who we serve and the best way to serve them, the public. A lot of people, obviously they're thrilled they're not paying their lawyer 5 hours of travel time for a 15-minute conference. So that probably makes sense in a lot of cases, but not everyone, not all of them.
So there is an appropriate way to use technology. My statement should not be taken as if technology should not be used where it makes sense, but you cannot erase interconnectivity of people being together and the relationships you build and the work you can do together. All of that being said, there was a time in Ohio where trial courts after Zoom said they were never going to come back together. They were going to try cases over Zoom as well. And the General Assembly enacted a statute that said, no, you will be trying your cases in person. So there is this chamber called the General Assembly, and they have a huge say in how courts will operate.
Okay, and I think something Justice Welch said is very appropriate. The Zoom meeting as an intermediary among people who already know each other is one thing, but you don't build personal relationships on Zoom. And so, to the extent the lawyers both know each other and I know both of the lawyers, maybe we accomplish almost as much with a Zoom meeting. But if nobody knows each other, there's no substitute for getting together and having that chat. If I could give you all a vaccine against incivility, it would look a lot like telling you to get involved with the Bar Association, okay? That to me, having interpersonal capital with other lawyers is the best possible vaccine against being what none of us want to be, which is the person that is tough to get along with and nobody likes it. That's a miserable way to go through life, okay? You get to decide every day, am I going to be the person that people enjoy being around and want to be near, or am I going to be the person that people avoid like the plague? And I'll just tell you, it's a lot more fun being the former, and you really do get to decide every day. You don't just get to decide, you have to decide. So it's a conscious decision, but I think being involved in bar stuff really is the best expression of that we have, and we can look back at the glory days when the Bar Association had bowling leagues and euchre tournaments, and maybe it's not, there's a lot more things competing, but please, if I give you one piece of advice, get involved with the Bar Association, because I think that does more to promote civility than anything else I can imagine. So I think we're sort of out of time. Does anybody have any parting shot you'd like to make? I didn't mean to take the last word, because that's stark admonition to my coffee mug that tells me to be less mean. But,
thanks for the opportunity to be here.
Well, please join me in thanking these justices for being here today.
Everyone hear me? Okay. Up. Better? Cool. All right. Thank you. One more round of applause for our justices and judges up here. Yay. Thank you. Hello, everyone. My name is Laurel, and I serve as the editor-in-chief on the Toledo Law Review's Board 57. And as our symposium now comes to a close, it's an honor just to offer a few final words. So this morning we've talked a lot about how civility protects the legal profession, how it's an indispensable component of our work as advocates, whether or not you choose to be zealous. And our panelists have emphasized a lot of about courtesy, dignity, respect, and humility. And although we are concluding here today, this discussion, this cannot be the end of the conversation about civility and professionalism in the law. As society progresses and evolves, so too do the standards of civility and professionalism. This dialogue is essential and must continue to ensure that the integrity of the legal profession is upheld. I would like to extend our appreciation to Professors Grenardo, Rigertas, and Seger for their insightful discussion on the evolution of civility and professionalism. And we are also grateful to Chief Justice Kennedy, Justice Welch, and Judge Knepp for sharing their thoughtful perspectives on civility in the courtroom. Thank you as well to the College of Law faculty and staff whose hard work made today possible. Congratulations to our symposium editor, Ed Maximzak, for organizing such an impressive installment in the Toledo Law Review Symposium series. And finally, to all attendees, your engagement and presence are what make this event meaningful. So thank you for being here. Before you leave, please remember to turn in your forms and surveys at the registration table outside the auditorium. For those of you who are seeking CLE credit, the activity code for in-person attendance is 611610. If you are virtual folks, 611611. And we will file the CLE forms on your behalf, so yes. And then just one final thank you for being here. We really appreciate you coming out, and have a good rest of your day.
Thank you.
Thank you.